May it please your lordship, I am praying for accommodation so far as item number 29, my lord. Can it be taken up after bail hearing matter, my lord? I have urgency in that matter, my lord.
Item
29, 29. After bail hearing, your lordship orders matter, my lord. Today the matter is fixed for consideration of interim prayer, your lordship. After bail hearing, your lordship may take up.
Who is for the other side?
Other side, I will inform.
Item 29.
29. After bail hearing, your lordship may take up.
Let us see.
My lord. Because last chance was granted to them, my lord. My lord, oblige.
May I please, my lord, item number 8. I have been telephonically informed by the PP that he is out of station. So he'll be reaching today. This matter can be taken up tomorrow, madam.
PP is out of station.
My lord, I have been telephonically informed this morning.
Okay. Is prayed for by Mr. Petitioner.
My lord.
This hearing, I counsel for the petitioner. Release this matter again tomorrow.
Grateful. Item number 37. My lord, my friend from the other side is also supposed to be here, my lord. My lord, there's some talk of settlement going on between the parties.
Okay.
So, my lord, could this be taken up later, my lord? Say, my lord, if it is not inconvenient, my lord, on 23rd September.
23rd September.
My lord, Mr. Niranjan Sharma appears for the private respondents. Well, for the petitioners, my lord.
You are for the respondent.
I am for the private respondents.
Okay.
He has most probably reached here. He told me on phone, my lord, he has reached.
Okay. So he has indicated for fixing of this matter on 23rd.
23rd September, my lord. It may take some time. Hey, my lord, he is here, my lord.
Okay. So 23rd September.
Yes.
Okay. Mr. N. Sharma, Lana counsel for the petitioner is present. Mr. P. D. Nair, Lana counsel for the respondent. All right. Okay. And Ms. L. Harvey, Lana additional PP
For state lawsuit.
for the state, and Mr. P. D. Nair, Lana counsel for the respondent are present. On the prayer of the Lana counsel for the party, let this matter be listed on 23rd 2025. Okay.
Okay, my lord, requests, my lord. Of course, though it's in orders, my lord, item number 11. My lord, the state of Assam is also a party. My lord, the government advocate is online, my lord. My lord, could I request that? My lord, could I request that the matter also be taken up on 23rd of September, my lord?
23rd?
My lord.
Okay.
My
We have no objection, lordship.
No objection. Okay. Mr. P. D. Nair, counsel praise for listing this matter on 23rd September 2023, to which Miss
M. Devi.
M.
Devi.
Lordship, M. Devi, lordship.
Has no objection. Accordingly, the prayer list this matter on 23rd September 2025. Okay.
My lord, there's an interim order, my
Much obliged, lordship.
There's an interim order, my lord.
The interim order passed earlier shall continue till the next, till then. Okay.
My lord, deeply obliged.
Obliged, lordships.
Please, your lordship. So finally, I have amended the application under section 438, 444, read with section 528 BNSS, where under power has been given to this Honorable High Court.
Which one is amended one?
Phase 1, cost titles. Phase 1, first phase, cost title. An application under section 438, 442, read with section 528 of the BNSS Act 2023.
There is two. 28, 28. The first one, 1A or 1? You have filed this petition under section
442, my lord. In the case of any proceeding, the record which has been called for by itself or which otherwise come to the knowledge of the High Court.
Mr. Counsel for the petitioner. This is an application filed under section 438/442 and read with section 5 to 8 of the BNSS 2023. For praying for restoration of the complaint, criminal case number 31/2022. Stop. Issue notice. How many respondents are there?
Only sole respondent, my
Okay.
lord. Only sole
So the
respondent.
respondent, returnable by 4 weeks. Start. The petitioner shall take steps upon the respondent by a registered post which AD, as well as by usual process within a week from today. Start. List this matter after 4 weeks.
Oh, okay, my lord. Highly obliged.
My lord, this
Yeah.
is a revision against an order passed by the first appellate court where my appeal against a decision in Keba was disposed of, directing the parties to share the land in equal shares. And what has happened? There was a dispute over a plot of land. Now the present petitioner approached the Keba. Other side was not present. Some other persons were present. And somehow the
Before the kebab.
yes, some other persons were present. Now, in a vague language, it has been put that he was there. Then, initially,
Otherwise, you are the complainant.
I'm the
You were-
complainant.
Okay.
And 2-3 witnesses have deposed in my favor. Those evidences were not considered.
Hmm.
And some of the persons who were on the adjacent boundary owner, they were not examined. And some who were examined deposed in my favor. Those evidence was not considered. And mainly, when there's an issue when both the parties are claiming and making claims and counterclaims, and the witnesses also deposed like that, possibly in such a case, de novo trial by the first appellate court is necessary because cross-examination will be necessary. Now the land is a valuable land, and initially what has happened, we filed appeal before the first appellate court. Thereafter, we filed a second appeal before the district judge. That was put to challenge before this court. This court said that no, under the new Act of 2021, Arunachal Pradesh Civil Courts Act, second appeal is not maintainable. So that is how we are before this court in revision now. And the last time when we preferred second appeal before the district judge it was also of the view that here is a case, cross-examination is necessary. So in a very slipshod manner, the Keba decision was taken. And then appeal also, it has decided, saying that no, possibly he was present. I'm just showing one, page 47, kindly have a look.
Page 47.
Page 47. This is an order passed earlier by the district judge in the second appeal, which has now been set aside already, but it was mentioned in paragraph 15 at page 47. Further on, going to this second paragraph of the impugned Keba decision, the claim of late O.M. Jamo, who is the respondent before your lordship, is clearly mentioned in the Keba decision. However, it is not clearly stated that the claim of O.M. Jamo was presented by him in person, but it is written in plural sense that the reason of dispute, as informed by the parties before the Keba, is that Sri Jamo sold the disputed land in the year 1972, claiming that his parent purchased the suit land from Pangam. The second paragraph of the impugned Keba decision does not suggest the conclusive presence of O.M. Jamo in Keba, but it was informed to Keba authority about the claim of O.M. Jamo. Possibly on this count itself, the order will go.
Now the land in possession is under whose possession?
My lord,
Land in question.
land is in our possession.
Okay.
Now, after the disposal of the last revision petition, Lordship will kindly have a look at this revision, because initially when we filed this appeal, from where I'm reading, the other side preferred a revision before this court, saying that second appeal is not maintainable. I considered, my lord, yes, under the 21 Act, second appeal is not maintainable. Page 56 is the operative part of the revision order last time passed by your Lordship here. Page 56, man.
Yes.
Operative part, second line. As such, the order dated 22/12/23 not being in accordance with law is set aside, and the respondent is given liberty to approach the appropriate court as per law against the order passed by the Civil Justice Division. So against that, we have filed the revision now. Revision will be maintainable. Appeal will not, appeal before the district judge will be second appeal.
After this, the KEBA decision, whether the respondent has filed any execution petition?
No.
No.
For execution, their file it is pending.
It's pending.
Pending.
Whether the execution petition has been stayed? No.
No, execution is pending.
Okay.
It is mentioned.
So, and the land is under your possession.
Land in my possession.
Will issue notice?
Yes.
Who are the parties?
Sole respondent.
So respond. Okay. Mr. D. Mozinder, Land Senior Counsel, assisted by
C. Gogoi.
C. Gogoi, Land Counsel for the petitioner. The petitioner filed this petition. Under Article 115. And Article 115 and or. under
I'm sorry,
Article-
this will be section 115 of CPC.
Hmm?
Section 6.
This is Article
My lord,
227.
my lord,
It should be section.
my lord, I'm sorry, man, this is, it should
115
be section
CPC.
115 the CPC read with
Okay,
article.
under Article 227 of the Constitution of India, read with section 115 of, kindly correct it,
My lord, I'll correct.
115 of the Civil Procedure Code, challenging the order, judgment and decree dated 5/6/2023, passed by the Learned Court of Civil Judge Senior Division Pasigat in CA under bracket Kebang bracket close number 46/2022, whereby the KEBA decision dated 24/5/2006 in Kebang case number HT -178/06/28789 has been affirmed. Okay, the para. The case with the petitioner is that he is under possession of this is your inherited land, ancestor,
Yes.
ancestral inherited land, located at where? Lengging Mone area, Pasigat. Lengging Mone area, Pasigat. In the year 2005, the respondent began to create disturbance, claiming that he has purchased the same land from O.M. Jama in the year 1972. Leading 72 Jama, leading to filing of the complaint before the Deputy Commissioner. The case was decided by the KEBA. The case was, it was Deputy Commissioner forwarded the case to KEBA.
Yes.
The Deputy
At that time,
Commissioner
21 Act was not there.
The Deputy Commissioner, sorry, forwarded the case to the KEBA, who decided the case on 24/5/2006. Okay, who by an order dated 24/5/2006 decided to divide the land in equal proportion between the parties. Being agreed, the petitioner preferred an appeal before the Court of Civil Judge Senior Division Pasigat, which was dismissed. Thereafter, the petitioner filed second appeal before the District Judge Pasigat, which was allowed. However, the filed civil revision petition before this court against the judgment and decree passed by the District Judge Pasigat. This court, by an order dated 26/6/2025, allowed the revision petition, holding that the appeal was not maintainable. However, the petitioner was granted liberty to approach the appropriate forum. By this application, the petitioner by filing this petition, the petitioner
Appellate order is page 24.
prayer
Prayer manual 18.
while challenging the order, the judgment and decree dated 5/6/2023, passed by the Land Civil Judge Senior Division Pasigat, seek direction for de novo trial by the Land First Appellate Court. First Appellate Court, in terms of second provider, appellate is on 54.
My lord,
Okay.
50
In terms of
proviso.
Okay, in terms of second proviso to section 15 within bracket 4 of Arunachal Pradesh Civil Code Amendment Act 2022. Issue notice returnable by 4 weeks. The petitioner shall take steps upon the respondent by a registered post within a week from today. As well as by usual process within a week from today. In the interim, the execution operation of the judgment and order dated. You are praying for
Stay of the customary
which
court
one?
order.
The order passed by the
Well,
CJM.
because appeal was dismissed, so the KEBA decision is standing now. My appeal was dismissed, so they can go for execution of the KEBA decision. That is why I'm praying for
Okay,
stay.
so your interim prayer is against the 24/5, okay, 2006.
Yes, yes.
Okay. Operation of the judgment and order passed by the KEBA on 24/5/2006 in KEBA case number HT 178/06/287-87 shall remain state till the next returnable date. Okay, list this matter after 4 weeks.
I'll be ultimately praying for de novo trial. I do not want any order from this one court, only de novo trial.
Okay.
Apply.
Please, Lordship.
Yes.
The petitioner, Lordship, before your Lordship is filing this civil revision petition challenging the Impion Kabang Samar issued by the Court of Traditional Based Council taking place Eastern District, Fasigat, whereby the petitioner was directed to appear before the Kabang to be held on 5/8/2025. That is tomorrow, Lordship. Lordship, here, this summon, Kabang summon was issued on the basis of complaint lodged by the private respondent before the village authority. Lordship, may I take you to the complaint?
Yes.
Page 56. 56 is the complaint, only of 2 pages. 56 is the complaint in local dialect. And then, Lordship, 58 is the translated, English translated copy.
58.
May I read, Lordship? To the Gambura, so-and-so village, so-and-so district, subject, Kevang complaint against Sri so-and-so. He's the petitioner before your Lordship. Resident of Nafid Village, POPS Pasigat, East Sian District, Arunachal Pradesh. Through this complaint, I beg to state the following points below. That during the lifetime of my mother, Sri so-and-so petitioner, stood as a witness and attested his signature on the will made by my late mother. But before the court, he lied that the signature was not his signature. Second, that thereafter, I am very much hurt by the statement deposed before the court by so-and-so. That when I, along with Sri so-and-so and so-and-so, went to the house of Obang Mengu for clarification, Obang told us that the false statement in the court was advised by an advocate. That after hearing his clarification, I requested him that whatever he told us, he shall make one affidavit before the court, which Obang refused. But he agreed that he will come to any court in order to tell the truth. That the village authority is the lowest court in hierarchy, as recognized by the AFR 1945. As such, the King Village Authority has the right to decide this instant matter. Therefore, Sri so-and-so himself told us that he is willing to tell the truth before any court, and in order to find out whoever advocate had told Sri so-and-so to give false statement, I request Gambura to initiate a kabang as per your convenience. Now, Lordship, the whole reading of this complaint does not discloses any civil offense.
Okay, so this is against the advocate also.
Yes, advocate, it's about the petitioner who disclosed the name of advocate, but that is there his statement. That is his version of complaint.
Whether the someone was issued against the advocate also.
No, Lordship, no. Someone was issued to the petitioner who denied his signature before the court during the trial.
There's only one respondent.
Yes, Lordship. Respondent is the
Will
complaint.
issue notice?
Lordship, I am praying for a stay because, Lordship, here I
Okay.
want to show, Lordship.
Mr. Jami. K. Lolin, sir. K. Lolin, Land Council for the petitioner. By filing this application under Article 227 of the Constitution of India, the petitioner seek direction. No, not that. Petitioner is challenges the summon. How many summons?
Third, this is latest one is the third one, Lordship.
Okay. Summon dated
Imputed summons.
18/6/2025, issued by the Gambura, Court of Traditional Village Council, Dikking,
Yes,
is, East Siang District, Pasighat. Issued under section 41, purportedly issued under section 41 of the Assam Frontier Administration of, within bracket, Administration of Justice, bracket close, Regulation Act 1945, directing the petitioner to appear before the KEBA, which has been refixed on 5/8/2025.
yes, Lord.
Start. Mother is still alive.
Lordship. Mother distributed the,
No.
no,
Okay.
no.
The case of the petitioner, the case of the petitioner is that mother of both the petitioner and the respondent.
No, Lordship. Lordship, respondent and his elder brother. Petitioner was witness to that will only, executed by the mother of respondent.
Okay. The mother of
Respondent and his elder brother.
the respondent and his elder brother executed last will and testament on 31/10/2006.
Yes. And in that,
Wherein
will,
the
yes.
properties of her deceased husband was divided between both brothers. Stop. In the said will, the petitioner was shown as one of the witness.
Yes.
Stop. The respondent filed a probate application before under other section 276 of Indian Succession Act 2025 before the additional district and session. Where is the additional district and session? When it was filed?
Lordship,
2012. Okay.
yes.
Additional district and session judge, Pasighat. During the trial of the said probate application, the petitioner was examined. Petitioner in his examination has denied his signature.
Not remember when he put his signature. Signature, he admitted his signature.
And in his deposition stated that he does not know
Yes.
how his name has been inserted in the will as witness.
Yes.
And he does not remember when he subscribed his signature
Yes.
in it.
Yes, Lord.
Stop. Being agreed by such statement, the petitioner filed complaint before the KEBA.
After 10 years, Lord. Deposition was given on 5/10/2015. And the complaint against this deposition, complaint was filed on 5/5/2025, after 10 years.
After 10 years?
Yes, Lord.
Okay.
Deposition.
Okay. After 10 years of such, the deposition was given deposition. The petitioner gave deposition on 5/5/2025.
2015. 5/10/2015.
2015.
Yes, Lord.
21/1.
Lordship, 2015, 5/10/2015, deposition was given and complaint was lodged on 5/5/2025 after
Oh.
10 years.
The petitioner gave his deposition on. No, it is 21/1.
Lordship, deposition was given on 5/10/2015.
5/10/2015,
Yes,
being agreed by the said deposition, the respondent filed complaint before the KEBA on 5/5/2025.
yes, Lords.
Based on the said complaint, the KEBA which Dicking. KEBA of which village?
Taking place, Lordship.
KEBA of Dicking village issued summon to the petitioner. It is the said summon against which this petition has filed on the ground that the what is this?
The complaint does not disclose any civil or
Okay,
offense of
the
civil and
complaint
criminal nature.
against the accused, the complaint does not disclose any civil or criminal offense against the petitioner. And the GB by issuing summon had exceeded the
Jurisdiction.
jurisdiction not vested on it. Okay, yeah, no, not vested on it, huh? Okay, so issue notice. Returnable by 4 weeks. Stop. The petitioner shall take steps upon the respondent by register post which as well as by usual process. Stop. Interim prayer.
Yes, Lord.
In the interim, in the meantime, the impugned third summon dated 18/6/2025 issued by the Customary Court of Dicking Village, East Siang District, Pasighat, Arunachal Pradesh, to the petitioner by fixing a KEBA on 5/8/2025 shall remain state till the next returnable date. Okay. Please this matter after 4 weeks.
Deeply obliged.
I'm sorry to interrupt your lordship.
Yes.
In respect of item number 1,
Hmm.
I'm praying for a liberty to correct the cost title. Lordship, you can kindly guide.
Item 2.
1, item 2.
Okay. And then yes. Mr. D. Majumdar, Language Sharing Council, submits that there is a typographical error in the course title and prays for allowing him to correct the same. The prayer is allowed. Okay.
May I beg your lordship? Lordship, this pre-arrest bail application, your lordship.
Well, this one.
Yes, your lordship. In connection with the Teju PS case, your lordship. Teju PS case, your lordship.
Teju PS.
Yes, your lordship. FIR is at page number 14, your lordship. The written complaint. Drawing PS case. Sorry, my lord. Page 14, your lordship.
Call for case there.
Yes, your lordship.
Scan copy. Okay.
Your lordship,
Mr.
one humble submission, your lordship. The next item, your lordship. Item number 5. Same accused person, your lordship. Same offense, your lordship. 2 FIRs.
There also will call for the case.
Yes.
Okay.
Lordship.
Mr.
T Siring, your lordship.
T.
Siring, your lordship. Sangpa
Hearing.
Siring.
Land counsel for the petitioner. Start. This is an application filed under section 482 of Bharatiya Nagrik Suraksha Sanhita 2023. Praying for grant of pre-arrest bail, apprehending his arrest in connection with throwing PS case number 41 stroke 2025 under section 62 within bracket 2 stroke 117 within bracket 4 stroke 191 within bracket 2 BNS read with section 3 of PDPP Act. Okay, issue notice. Call for the scanned copy of the case set. Issue notice. Miss Ginny, Ghana Edition PP, accept notice. Establish this matter
On 14th, your lordship.
on 14th. Okay.
The lordship entering my
Item
oblige, your lordship.
5 is also same, your lordship.
5 is also same.
Only
Uh,
except for the
This
sections.
is 4 and 5. Okay.
Repeat.
Oblige, your lordship.
Right.
No, my lord. My lord, this petition, my lord, has been filed under 528, my lord, for passing and setting aside of impugned notice dated 25/7/2025, my lord.
What?
Whereby my lord, petitioner has been directed to remove the pains, my lord, with immediate effect. Petitioner has been directed to remove the pains.
Yes, yes.
With immediate effect, my lord. So, my lord, what happened, my lord? Petitioner is owner of land, my lord, private land, my lord. Measuring 5,430 square meters. Wherein, my lord,
Where is the impugned order?
impugned order is page 26, my lord.
Page
26.
26.
In excerpt 3, my lord. Type copy is in.
So the deputy commissioner,
Yes, my lord.
that copy is at?
27, my lord. Married.
Yes.
Notice to remove the fencing erected on the Cloney approach road connecting Upper Leru village. Whereas it is brought to the notice of the undersigned that you have erecting a temporary barbed wire bamboo fencing on the Cloney road connecting Upper Leru village to main road towards Government Secondary School, Leru, since February 2025. Whereas the resident of Upper Leru village has filed complaint in writing stating that the said road has been used by the public of Upper Leru colony from the very beginning since the establishment of village. Further, it is also reported that you are not complying the decision of the village authority in this regard. There is no decision of village authority, my lord. And further, my lord, in whereas the town magistrate and OCPS Likavali has inspected the site on 23/7/2025 and submitted a report that you have illegally encroached the colony road and
You have to
erected.
remove, it appears.
Yes, my lord.
Yes, it appears that you have to remove.
No, my lord. This
This is
deemed to
public
be
road. This is
deemed
public
to-
road.
Yes, my lord. This deemed to be proceeding under section 152 of the BNS, my lord. Wherein, my lord, certain procedure has to be followed, which is mandatory, my lord. May I take, my lord, to provision of section 152, my lord. Yes, my lord. Section 152, my lord. 152, my lord.
Of
BNSS.
152.
Yes, my lord. One 52, my lord, correspond to section 133 of CRPC, my lord.
Yeah.
May, my lord. Whenever a district magistrate or a subdivision magistrate or any other executive magistrate, especially empowered in this regard, in this behalf by the state government, on receiving the report of a police officer or other information, and on taking such evidence, if any, as he thinks fit, that any unlawful obstruction or nuisance should be removed from any public place or from any way, river or channel which is or may be lawfully used by the public. Skipping, my lord, rest, my lord, after F, my lord, such magistrate may make a conditional order requiring the person causing such obstruction or nuisance or carrying on such trade or occupation or keeping any such good or merchandise or owning, possessing or controlling such building, tent, structure, substance, staying, well or excavation or owning or such possession, such animal or tree within a time to be fixed in the order. So, my lord, when conditional order is passed, my lord, time should be specified, my lord.
So here no time was given.
Yes, my lord. Immediate effect. And my lord, after that, my lord, skipping this last
When
part.
this was passed, 25.
Yes, my lord, 25/7.
You make a request to give you some time to remove.
Though, my lord, I have been not asked to reply the this notice, my lord. I have filed a reply, but nothing has been done. But
Well, where is your reply?
it's in
Reply. Have you sought for some time?
I have requested for reconsideration of this notice, my lord. In Annexure 4, my lord.
So according to you, this immediate doesn't have the time.
Yes, my lord. Section 152, my lord, because, my lord, if I object, my lord, I have to be directed to appear before magistrate, my lord, or so cause has to be issued as to why this order.
What is your prayer in this reply?
My prayer, my lord.
Have you sought for time or what?
No, my lord. I have.
Do you have the any document to show that that land belongs to you?
Yes, my lord.
Where?
My lord, LPC, my lord. LPC was issued in my favor also, my lord. That is my private land, my lord. For
Okay, then that becomes a dispute whether this comes under that LTC or not. Will issue notice? Yes, what do you say?
Lordship, here Lordship, 152 Lordship, section, whereas the magistrate has the power to issue notice Lordship. Here Lordship, in this notice Lordship, the only thing that Lordship, magistrate Lordship has issued, this is what kind of issued notice was, but the Lordship time period is not given. Here instead of the time Lordship, they have mentioned that you have illegally encroached the colony lot and erected fences thus obtain the movement of public. Therefore, you are thereby directed to remove the above said fencing immediately, Lordship. Immediately, what is their Lordship? That means, Lordship, they have enough time, Lordship, because time period is not mentioned. But after that, Lordship, it's clearly mentioned that otherwise your action attract legal action under appropriate provision of law. That means this is kind of notice. It's not a order.
Public laws.
Yes, Lordship.
my lord, it is deemed to be, my lord, absolute order, my lord. It's because, my lord, this notice.
So who are these private respondents?
Private respondent, my lord, there were 28 complainants, but I have made only 3 persons as a.
Why you have chosen 3 only?
My lord, for sake of
Because
brevity,
it's a
my lord.
public.
Yes, my lord, for sake of brevity, my lord, and their contention will be same, my lord. So that's why I made only 3 persons as a on representative capacity, my lord.
You have chosen only your enemy.
No, my lord,
Okay.
for sake of brevity, my lord.
So listen. Third, Mr.
El Nasim.
L. Nochi, Land Counsel for the petitioner. Sir, it's 5 to 8. Where is your prayer? Just
My lord, it's in page 16, my lord, and my interim prayer is in page 17, my lord.
the petitioner filed this application under section 528 of Bharatiya Nagrik Suraksha Sanhita 2023. Praying for quashing and setting aside the impugned notice dated 25/7/2025, issued by the Deputy Commissioner Likavali, Lower Siang District, Arunachal Pradesh, whereby the petitioner has been directed to remove the fencing erected by him immediately and clear the colony road for convenience of public staff. Issue note now. Whether record required to be called for? Call for the record, relevant record, issue notice. The petitioner shall take steps upon the respondent by a register. Just a minute, huh? Issue notice, huh? Since Miss L. Hagelane, additional PD, accept notice on behalf of the state respondent number 1, no formal notice need be issued to the said respondent. Staff, the petitioner shall take steps upon the private respondent by a registered post with AD as well as by user process within a week from today. Staff, this matter after 4 weeks.
My lord, till then, my lord, impugn notice may be suspended, my lord.
Interim, no, this is public road. It's very difficult.
My lord, otherwise, my lord,
After the appearance, let us see the record. Okay.
my lord, in fact, my lord, Supreme Court
You
says,
probably may have to remove.
Yes,
And then if you satisfy, you'll have your land, That if
my lord,
your
actually, my
LPC.
lord, no inconvenience has been caused to public. It's because, my lord, main road is
Why these 20 people had to?
main road is there, my lord. Government constructed road is there.
No.
So this
Even
is
if there-
this is for
Even if there is a main road, but if it was a subway or sub road or footpath also, if it existed earlier, it has to be. It has to be broadened also.
that is there, my lord. But this particular road has been constructed by me for my personal use, my lord. By passing of time, people of Liru village use this road as shortcut road. Whereas there is main road is there.
Gives some advantage to the public also. You are rich in land, gives some advantage.
Yeah.
Some benefits to the people
In my lord,
around
there
you
is
also.
alternate route also in my lane, my lord.
Maybe. Let us see the record. If you satisfied, no problem. Don't worry. Because this is your land, if it is your land. Okay.
Okay.
Yes.
Your Lordship, I have very limited submission to make regarding this revision petition. This revision petition, Your Lordship, it has been filed because the petitioner was aggrieved by the term, categorically aggrieved by the term used second wife in the impugned order passed by the learned JMFC UPI. Then the petitioner had filed a criminal appeal along with an IA for condonation of 42 days, delay of 42 days, which was rejected and disposed of by the Court of Sessions Judge UPI. So this revision petition has been filed.
You have an objection to
Condonation, my condonation of delay of 42 days was rejected.
okay. Rejected.
Yes, Your Lordship.
So what can we do?
Yes, Lordship, in the petition, in my criminal appeal and IA, I had categorically mentioned, I have also mentioned in page 6 of para 7 in my revision petition here, the reason why there was delay of 42 days. It's in page number
See,
6.
The court has exercised its discretion not to found that. How many? 42 days in
42
filing?
Criminal revision as well as the IA for condonation of delay. 42 days delay.
Let us see, where is the
Impugned order
order?
is at page 36 of my petition. Page 37, para 4. of the order.
What is that?
Here it is submitted by the learned counsel for the petitioner that initially the case was heard on 15/5/24 and the judgment and order was supposed to be passed on 26/24. But on the said date, the case was not listed and the judgment and order was passed by learned JMFC on 25/6/24. It is submitted that the petitioner did not have any knowledge regarding the said judgment and order and only on 21/8/24. When they had inquired in the office of the learned JMFC, then they have come to know about the said order. It is submitted that by the meantime, the delay of 42 days is caused. So that is the delay of why 42 days, delay of 42 days in filing the criminal appeal and IA.
What is the reason for rejection of this prayer?
The-
What reason the court has given?
It is on in para 6, last portion, 1, 2, 3, 4, fourth last. It is observed that the ground of delay that the petitioner did not have knowledge regarding the impugned judgment and order is not well founded, and accordingly the same cannot be accepted as ground for condemnation of delay, Your Lordship. This is the reason.
You stated that the date of hearing was fixed on 13/5.
No, Lordship. On 15, it was heard on 15/5/2024, and it was supposed to be, the final order was supposed to be on 26/2024. However, it was not listed on 26/2024. And the petitioner,
Have you annexed that order? Okay,
yes, Your Lordship.
the record is there.
Mm,
What is?
Page number 14. Page number 14.
40.
14. 1-4. Page number 14, last lines. Fixing 20/06/24 for final order. And I have also annexed the cost list of,
No, when final order was passed according to you?
then final order was passed on 25/6/24.
So otherwise it was fixed on 20.
Otherwise, yes, Your Lordship, it was fixed on 20. However, that was not listed on 20. I have also annexed the cost list of 26/24, where the matter has not been listed. And the next date was also not assigned. And later, when we inquired the date for the next date, when the matter was to be listed, that is when we learned that the order was already passed.
File objection. Yes, I'm raising maintainability of this instant criminal revision. They are misrepresenting. Wait, I just want to ensure you are present. How many respondents are there?
One respondent,
Only
Yes.
sole respondent.
only sole respondent, Your Lordship.
Impugned order, where was the impugned order?
Impugned order is at page
Yeah, on the
page
36.
36,
36 is order dated 22/11.
22/11. Yes, Your Lordship.
So, but you have challenged which order?
Yes, we have, yes. Condemnation of delay of 42 days was
22/11.
rejected, yes.
You said that agreed by the impugned order 25/6. What is this 25/6/2024 order? This is the judgment order dated passed by the learned trial court. Trial court order is 25/6.
25/6, yes.
Okay, you agreed and being agreed we filed.
Yes, after the impugned order by the learned JMFC was passed, then we had pressed for criminal appeal and IA for delay of 42 days, condemnation of delay of 42 days, which was rejected.
Then since that was rejected, then the.
Then we
appeal-
have,
appeal
yes.
Automatically.
Yes,
extends-
then we have approached this honorable court with this revision petition.
So in IA, you also filed objection. Yes, Your Lordship, before the appellate court. Yes. May I please, Your Lordship? If I may, Your Lordship. Yes, Your Lordship, the ground taken by the petitioner in the appeal, the condemnation of delay, Your Lordship, is that they were not present while passing of the impugned judgment passed by the learned trial court. That is order dated 25/6/2024. Their sole contention was that they did not have the knowledge while passing of the order dated 25/6/2024. Kindly peruse, Your Lordship, order dated 25/6/2024. In my counter affidavit, Your Lordship, it is in page number 58, Your Lordship, not in this petition. Not in this petition. They have not annexed this order also, Your Lordship, 25/6. Yes, Your Lordship. They are misleading yourself. And peruse, Your Lordship, hold. Page number 58. So page number 58 of my counter affidavit. Yes, page 58. Order dated 25/6/2024. Today matter is fixed for judgment. Learned counsel for both the parties are present, Your Lordship. Counsel are present. Judgment is pronounced in open court. The counsel were present during passing of the 25/6/2024, and what their contention for condemnation of delay is sole ground was that they were not present and they did not have the knowledge of the passing of this 25/6/2024. This itself is a misleading statement, and the session court has rightly passed the order dated 22/11/2024. Your Lordship, kindly peruse the order dated 22/11 passed by the learned session court, Your Lordship. In paragraph 6, Your Lordship. Paragraph 6 of order dated 22/11/2024, Your Lordship. It will find at page number. Operative portion is in page number 65 of my counter affidavit, Your Lordship. Page number 65 of my counter affidavit. Yes, ma'am. The next page is, okay, this is the order in BB case. This is the terms. No, just a minute. Yes. Okay. Page 64 onwards, it is start, Your Lordship. Order dated 22/11/2024 passed by the learned session court, Your Lordship. Okay. And the operative portion is in page number 6 or 65, Your Lordship. Paragraph 6, Your Lordship. Yes. May I read, Your Lordship? I have carefully perused the petition as well as other annexed documents and seen that though the petitioner submit that the case was heard on 15/5/2024 and next date is fixed on 26/2024, but no such order dated 15/5/2024 is annexed with the application. It is submitted that the impugned judgment reflects that the date of hearing was on 13/5/24, but no such order dated 13/5/24 is also annexed with the application to show that the case was fixed on 26/2024 for judgment and order. I have seen the impugned judgment and order was passed on 25/6/24, and the order dated 25/6/24 reflects that on the date of judgment and order, learned counsel for both the parties are present, Your Lordship. It is observed that learned counsel for both the parties have knowledge regarding the impugned judgment and order as the same was passed in their presence. It is observed that the ground of delay that the petitioner did not have knowledge regarding impugned judgment and order is not well founded, and accordingly the same cannot be accepted as a ground for condonation of delay. Your Lordship, they have misled. The learned station court has lenient enough to not initiate any perjury case against them because they have misled the honorable court by stating that they have not present in the court while passing of the order dated 25/6/2024. It is reflected in the order sheet itself that they were present and they have the knowledge of passing of the impugned judgment. And therefore, this criminal revision petition is not maintainable because there is no illegality or irregularity done by the learned session court, Your Lordship. And regarding the claim made by the petitioner that she is the first wife of the husband, it is baseless, Your Lordship, because they never mention any specific date when she had married with the husband, Your Lordship. However, in my case, Your Lordship, I have made an affidavit, I have made a paper publication that I have married to Mimbarak Sahib, Your Lordship. And moreover, Your Lordship, the person who were present in the marriage ceremony, they have made a declaration that the marriage was solemnized between me and the husband in the year 2000 itself. But the petitioner never had mentioned any that when they have married with the husband, Your Lordship. Their basic contention for the first wife is that they have given birth to a baby boy before the respondent hearing. I'm challenging the maintainability on the ground that the petitioner has misled the honorable court. If I may, Your Lordship, I would like to place some judgment, Your Lordship. Just a minute. Let us see that. I will go. You are aggrieved by 25/6/2024.
Yes.
Just a minute.
Your Lordship, if you may allow, regarding the first wife and the second wife. So here they're claiming that they're the respondent is the first wife. However, Your Lordship, on 28/4/2023, the respondent herein, she had instituted a DV case against the petitioner in the State Commission for Women. So there, the husband had written to the APSCW, he had written that all the allegations of domestic violence and mental torture leveled against the
No,
petitioner
this DV case was filed by whom? Me.
by the respondent.
Respondent.
Yes, and the husband had categorically mentioned that the petitioner is the first wife and the respondent was the girlfriend. And unfortunately, she had later on she had a baby girl, and that is how then he had to marry her, and then she is the second wife.
Whether the first wife has also child. And
Yes, first wife has 2 children.
okay.
And after the husband had written the letter clarifying all the allegations in the APSCW, in the State Commission Women, in the Office of the State Commission of Women, the respondent, then she filed another domestic violence case in the learned JMFC.
Your Lordship, the learned session court has rejected the condonation of delay. And it is settled law that merit of the case cannot be heard while hearing the condonation of delay. It is judgment of the Honorable Supreme Court, Your Lordship. Now, merit of the case cannot be heard, Your Lordship, because the session court has rejected the application for condonation of delay. what is this order? What the order says? You are agreed by this order.
Yes, agreed by
Now
the.
she is agreed by the,
In the DB case.
now she is
Actually-
agreed by the session court order, Your Lordship.
Now,
22,
because
11,
this-
2020.
yes, that court, the judgment was 25/6. I'm actually aggrieved by the 25/6/2004 judgment, and yes, and for that I had filed a
This
criminal appeal.
25/6/2024
Yes,
against you.
yes, where twice they have categorically mentioned second wife for me
This 25/6/2024 was filed by me.
by the respondent.
So what is the consequences of this order? 25/6/2026, 24?
Uh, because the word second wife is used for the petitioner, so that will remain forever. Wherever she goes, she'll be considered as the second wife, though she is the first wife.
No, Your
He's
Lordship.
not aggrieved by any of the other orders, if the protection order, anything, but except the word term second wife used for her.
No, but what is the effect of this order? Only that the petitioner is the first wife. Second.
No, Your Lordship, I'm the
wife.
first wife.
Petitioner,
Your Lordship, can you, in DB case, you are.
Yes, yes, I'm the first wife, Your Lordship.
she's claiming to be the first wife.
Your Lordship, kindly peruse, Your Lordship, my documents which I have annexed in my counter affidavit, Your Lordship.
No,
For-
just
For
a
a moment,
minute,
Your Lordship.
You are for the petitioner in the
DB
case
case.
number 21.
Yes, Your Lordship.
And this was passed in your favor.
Yes, Your Lordship, in my favor.
Okay, against you.
Yes.
How you are adversely affected by this order?
Your Lordship, I'm not concerned about the other orders, like the other reliefs granted. However, the word second wife,
Which part?
if you see on page 60 of their reply, page 60.
No. Here in the judgment,
Yes, page 60 is the judgment,
60.
60.
Okay, Tara.
The instant proceeding under section 12 of PWDV Act is brought against the second wife by the first wife.
Okay, you agree by this
Yes, and one more.
mentioning of second wife.
Yes, second wife. And again on page 61,
So otherwise, according to you, you are.
I am the first wife. But here I have been portrayed as the second wife, whereby my husband has also given a written clarification that I am the first wife. And all the charges leveled against me of domestic violence and mental torture against the
You are
respondent.
agreed by what else other than this second wife?
Nothing else.
So that is why I could not find anything
Yeah,
against
yeah.
you.
And moreover, they have not challenged this order dated 25/6/2024.
Okay. You are
They
agreed
have
by-
challenged the order dated 22/11 passed by the learned session court. They ought to have challenged, if they are agreed, Your Lordship, they ought to have challenged order dated 25/6/2024 passed by the learned JMFC court, Your Lordship. But they have challenged the order
Your Lordship,
dated
once the
20
petition,
Just a minute.
Mm,
So you are agreed by this word second wife.
second wife, yeah.
You are happy with the second wife, first wife.
Since I'm the first wife, Your Lordship.
Okay. So husband will be the right person to clarify.
Yes, and husband is, he has written a letter addressed to the State Commission of Women, where he has categorically stated that petitioner, I am the first wife. And respondent was the girlfriend. Unfortunately, she had a baby girl. Then he had to keep her as his second wife.
That is unfortunate. So,
Your Lordship, I'm raising the maintainability of this criminal revision.
okay, just a minute. And then before the appellate court, you have challenged by being agreed by the
Yes.
second wife only.
No, Abhi, yes, the order where I have been like categorically mentioned as the second wife.
Second wife. Other than that, nothing otherwise.
Other than we don't live in the same house.
Yes.
We have never stayed in the same house. Me and my husband, we stay in a separate residence. And the respondent, she resides in a government quarter. So we don't share the same house residence.
Where have you stated that you have agreed by in the petition? Or before the?
Yes, in my petition. In my petition, paragraph 2.
No, just a minute. What is the way to solve this first wife, second wife problem, according to you?
According to me, Your Lordship, finally, Your Lordship, there is page number 67, Your Lordship, of my counter affidavit.
Because both may claim.
Yes,
as
sir.
a first,
Both may claim, Your Lordship.
but then the husband would be the right person to clarify. So what is the way? Page number?
67, Your Lordship, and except 2 series.
No, this is on affidavit.
Yes, sir.
Signed by whom?
The
No. So
This
because
one.
that is why I'm saying
and there is a paper
the
publication.
evidence would be necessary where husband will give statement, who is the first, who is the second.
Your Lordship, husband is already given a letter at page
No,
number 30.
not the letter.
Yes.
Because now there is affidavit.
Your Lordship,
In my
It's affidavit,
the
the name change.
respondent will.
This is the name change affidavit.
it's a name change, and I had mentioned specifically that I had married with these Minbar
This
Aksa
is your
on that.
declaration, no?
Your Lordship.
This is your affidavit is your
Yes,
declaration.
sir.
So
it,
that
it,
we-
it has been executed, Your Lordship. Before the magistrate.
Maybe, but this is your.
In this affidavit,
Your
Your Lordship,
declaration.
I have mentioned the date
No,
of my
husband
marriage.
has to declare. Husband has to declare.
Your Lordship, there is no such declaration by them. But however, Your Lordship,
Hmm.
there is no specific averment by the
See-
petitioner when she had married with Mimbar Aksa, Your Lordship.
Okay.
There is no specific, and moreover, Your Lordship, this criminal revision petition has been
Because
filed by the petitioner.
the only dispute is first wife and second wife.
Yes, Your Lordship. This
And probably instead of letting it remain undecided, I think this needed to be decided by the husband to facilitate husband to decide what is the way out, both. To decide outside. the
Your
court-
Lordship, the husband is ready to come and give his statement in the
See,
court.
so in the court,
Yes.
supposing court direct, whatever may be, allowing the petition, not allowing the petition, whatever may be, but then court will find out some way so that both the petitioner and the respondent get justice
Yes.
and the truth comes out.
Yes, Lordship.
The court would also like. Can it be settled outside?
as per my
Because
limited
this is
knowledge, Your
a
Lordship.
question. Husband knows when.
I'm
If
just
not at the same time.
Your Lordship, since I'm raising the maintainability, whether those merit can be decided in this criminal revision petition or not.
So, no, that is what I'm saying. Because ultimately, this has come under.
397, Your Lordship.
Hmm?
CS file application under 397.
So, see, this is revision.
Yes,
Revision.
and this is not maintainable, Your Lordship. I'm raising maintainability. Your Lordship.
I thought this is criminal petition.
No, this is criminal revision petition, Your Lordship. And that regard, your lordship,
That is why your
I may-
lordship,
I may be
the delay of condemnation is necessary, so that if the delay
how can be,
is
your lordship?
allowed,
They
if the
have
condemnation
misleaded
is,
the honorable court, your
no, if
lordship.
this condemnation is allowed,
When
then
your
the
lordship,
trial may
I'm
proceed
praying
again.
that strict action may be initiated against the petitioner for
So that the
misleading the
trial may
court.
proceed
Yes.
again
Please,
afresh.
please, what we'll do, I'll pass order next week, but then to try to explore the possibility of settlement. This is only question of first wife, second wife. No need to enter into such complications by spending money in the court. This is
Your
a simple
lordship.
question. Husband will clarify, even if you claim, if you are second wife, really second wife, even if you claim also, you bring all everybody, but then if the husband wants to clarify that you are second wife, you have to be.
Mm,
The population or the majority will not do here.
mm.
Because the truth will prevail.
You know,
In
fact
your
is
case,
that-
it's all the same.
Fact is that I belong to a non-tribal group.
So-
So she belongs to a tribal group. That's why she is overpowering me, your lords. The fact is that, your lords.
We do not, but then maybe whether tribal or.
This is not the fact, your
Husband, the
lordship.
wife
This is not the fact.
husband, the wife is wife.
This is the actual
Even if
fact.
the tribal
Because
claims
of
also.
such harassment, I have filed for the Women Commission also, and I have filed the DB case against the petitioner, your lordship, not against my husband, your lordship. Since she is harassing me, she belongs to tribal person and I belong to non-tribal, and she's
Because it's a
overpowering me.
division case, we cannot call the husband and ask who is the first. We cannot.
Yes.
So there is a difficulty.
As per my limited knowledge, we have to, your lordship, decide whether this criminal revision petition is maintainable or not.
Okay, so what we'll do, try to explore, otherwise this court has decided, we'll pass order.
Yes, but that will.
So try to explore, we'll get it listed next Monday.
Monday.
Try to explore. Tell the difficulties, both
Your
when
lordship,
it comes to you.
it will be
Because
very
it will go
prejudice to
again,
your lordship, because
even if it go again.
she
or
will
it is sent again.
compel my husband to depose before the court or any authority that she is the first wife.
If he's blaming that, she might also compel the husband
Okay.
to do the same.
So there is a lot of possibilities, scopes, and then.
See,
So
my
that-
husband is
that-
living with her.
Because I'm the first wife, your lordship.
No, your lordship. Her.
Okay. Anyway, we'll get it listed. Just try to explore. This is unnecessary, it appears. Okay. Small thing, small thing to be decided, but then making it so complicated.
Your lordship, one
Decide.
minute, one moment, your lordship. Kindly peruse the
Then,
court,
okay.
page number
I've seen.
73 also.
I've seen, what is that?
In this order
Both, okay.
also,
Miss, you are Miss
Miss K. Choton,
K. Chotam, Land Council for the revision petitioner. And Mr. Elbam,
Ivan.
Council for the.
Ivan.
Oh, sorry, IBAM. IBAM, Land Council for the respondents are present. List this matter again on Monday, Tuesday. It will be Wednesday.
This
Next
Wednesday?
Wednesday, not this Wednesday. Next Wednesday would be 13th. Please explore. Otherwise, this court will pass order. I understood now. Yeah. Okay.
highly obliged.
Whatever.
May Lordship. Lordship, this is a bail matter. It was taken up on Friday. Lordship, what's the opinion that May Lordship. Lordship, this is a regular bail. Here, the applicant is the brother-in-law of the alleged accused, who was arrested in connection with Itanagar PS case number 97 of 25. So, here the alleged accused is behind the bar for 40 days, Lordship.
40.
40 days.
And what is the offense?
Offense is Lordship 329, that is it's a bailable offense 309, that is robbery.
What is 329?
309?
BNSS. BNS.
Yes, ma'am.
What is 329?
329 is criminal trespass, Lordship, and house trespass.
And what is 309?
309 is robbery, Lordship. It's come under robbery.
Okay, what is this?
30936. Corresponding will be Lordship. 330 IPC Lordship will be 390.
What is 3, 5 is equivalent to 34?
As equivalent to 34, section 34.
Where is the FIR?
The FIR is in page 13, Lordship. This was lodged by the complainant, Lordship, on 24 June of 2025. It was made before Itanagar Police Station on 24 June 2025. Married, Lordship.
Yes.
The subject said immediate action request against assault and theft by miscreant at News 1 Today at office. Respected sir, I so and so, that is the complainant CEO from editor-in-chief of News Today Group, Stroke Avat TV. I am writing this letter with deep anguish and concern to bring your notice a grave and a violent incident that had occurred at our office premises today. A group of miscreants led by so and so, chairman and ex-MLA of Barming, forcefully entered our office and physically assaulted me, causing multiple injuries all over my body. The attack was brutal and carried out with clear intent to cause grievous harm amounting to an attempt to murder. Further, so and so pointed a pistol to my head and forced me to write apology. The attack also looted the following items from our office and person. So the one office laptop, one CC camera, damaged CC camera unit, one gold chain, so and so. The reason for this violent and unlawful attack seems to be from the fact that our news channel had posted a news report about so and so arrested by the Chennai police on 24/6 of 2025. The nature of the assault and targeting looting clearly demonstrate a premeditated act with criminal intent against a media professional, which is not only shocking but a direct attack on freedom of press in our democratic country. I therefore request your office to. This is the Lordship FIR. Lordship, going through the FIR, he has made an allegation, white allegation, which is not true, Lordship. So Lordship, he has made here that a pistol has.
You are the name accused in the FIR.
No, Lordship, I'm not in the FIR. Lordship, here the alleged accused is a advocate by profession. So what has happened, Lordship, in this matter?
He has been arrested. And how many persons were arrested?
Lordship, only 2 persons were
The
arrested.
name accused in the FIR was how many of them? They were also arrested.
Never arrested, Lordship.
And your name is not there.
My name is not there in the FIR, Lordship. The main accused whose name is given is also not arrested, Lordship. The main, that is the, whose name is mentioned in the FIR has not been arrested, Lordship.
They were not arrested.
Not arrested, Lordship.
They were not arrested.
Lordship, only 2 persons were arrested in this matter. The other person was, bail was given on 19/7 of 2025, that which I have annexed in my annexer. That is annexer 6. Annexer 7, Lordship, by the district and session judge. We had 2 persons were arrested, Lordship.
Only 2 persons
Only
were
2
arrested.
persons arrested.
So who are they? Where do we find the names?
Page number 25, Your Lordship.
25.
No, 25 is Lordship.
It's the names are given. Second paragraph, Your Lordship.
Okay, then. Okay, earlier you moved the bail application before the judicial magistrate.
Before the judicial magistrate. Before on 2/7
This is bail of
2/7/25. Order is.
This is for. Have you annexed the arrest?
Arrest memo, I have
memo?
arrested, Lordship. I have arrested. Arrest memo is on page 17, Lordship.
17.
Yes.
So this is you. This is you.
Yes, ma'am.
And then who else was arrested? Not annexed.
That not annexed, Lordship. He has been already taken out
It's at
from bail.
page number 19, Your Lord. The accused challan.
No.
Lordship, in accused challan, we can see 2 persons were arrested in this matter. That is page 19, Lordship. Page 19. 1 and 2, Lordship.
But FIR, the page 13 is FIR. Is the page 13 only FIR?
Yes, Lordship. It's only
Or there are some other FIR also?
No, in fact, both of, as per the case diary, both of them have surrendered and therefore they were arrested, Your Lordship.
Okay, and then the main accused has not yet been arrested.
He has
What
not
the-
been
What the case diary says about the
Your
main
Lordship,
accused?
if I may, Your Lordship,
Yes.
in the FIR, there is an allegation that they had forcefully entered, Your Lordship. However, the statement of the person who is named in as an accused, Your Lordship, he has stated that he was invited by the complainant, Your Lordship. There was an publication of a newspaper news, Your Lordship, by this complainant who is the CEO of a particular news channel, Your Lordship, that with regard to certain case, Your Lordship, against the person named in the FIR, Your Lordship. Therefore, he was invited by the complainant. He went to their office, Your Lordship, and the parties, due to certain disagreements, Your Lordship, the parties, the accused.
Why would he invite the person against whom he has published? That's not possible.
Yes, his own statement, Your Lordship. In his own,
Informant.
the complainant and the person who is named.
Complainant stated himself.
Yes, Your Lordship.
He invited the
Yes, Your
accused.
Lordship. There was already an issue because he has released the press release, Your Lordship, with regard to a news.
After release, he invited the person
Yes.
against he has published.
Yes, Your Lordship. His
How is-
statement is there, Your Lordship.
Statement is there.
Yes, Your Lordship.
The logic doesn't.
There might,
There is no logic in that.
yes, Your Lordship.
Lordship, it's out of court. I mean, what I mean to say, Lordship, this media person, what that is out of context, Lordship. What they do is, Lordship, they take day one news report, you know. What they do after publishing, and they'll call him, and he'll take his brief statement. That is what, Lordship, I mean. If I'm not drawing him. That is what out of record I'm saying, Lordship. Since the complainant is a news person, Lordship, what they want the news to be
Is there any
published.
material against present accused?
Your Lordship, there, as per the FIR, there is an allegation that there was a use of gun which is not there in the city, Your Lordship, and even the complainant does not reveal about it. Only the DVR, if Your Lordship see the FIR, Your Lordship, the item number 2 is one CC camera DVR, Your Lordship. CC camera DVR, Your Lordship. This was also given by the complainant to the present accused as per their statement.
Cannot.
As per their statement, Your Lordship.
Something more is there, it appears. And then the police is the one who knows everything.
Yes, the DVR was handed over to the police by the present applicant, Your Lordship. I-
Petitioner.
Yes, the petitioner, Your Lordship. And with regard to gold chain and damage, CCTV camera has been damaged, but then since the CCTV was not functioning at that point of time, Your Lordship, the police could not have traced out as to if there was any act of snatching the gold chain and other activities. Your
Okay.
Lordship.
What is your submission? You object bail or what?
Your Lordship, as if I have just flag marked the statement of the accused, Your Lordship.
Okay, this is accused.
Yes, Your Lordship.
No,
The
not the
applicant,
accused.
the applicant.
But then where is the
The statement of the
Statement of
complainant is
informant.
in the first page, Your Lordship. The second bunch,
Hmm?
in the second bunch, first page, Your Lordship.
Why there is two copy of the statement of the informant, same, different,
Different, your lordship.
recorded on different date?
Yes, your lordship. After examination of the accused named in the FIR, your lordship, he was again called for giving his statement.
In the second statement, also it appears that he has reiterated what he has stated earlier.
Yes, your lordship.
Same thing. He has repeated. There is a clear case against the accused. This will be difficult if his statement is correct. Now, where is the
The
statement of the
statement-
present accused?
Yes, it's flag marked, your lordship.
Flag mark.
Yes.
Okay. Oh, he took the name of the present accused also.
Yeah.
Yes. So, you moved bail application earlier, it was rejected.
It was rejected before magistrate and the session court, and I'm finally here before the Honorable High Court Lordship.
Okay.
Lordship, here also on the day itself when they were produced.
How many days you have been there?
40 days, Lordship. Today.
So, anything?
Yes, Your Lordship, even the applicant in his own statement has stated that there was a provocation and therefore he punched the complainant, Your
No,
Lordship.
no. Where he is there?
Uh,
Applicant,
Applicant,
the applicant has
Present
stated
applicant.
provocation, but
Present.
then the victim has not stated that.
no, no. What I'm trying to bring to your Lordship's notice is that he himself has admitted that he has punched the complainant
Yes,
here in Your Lordship. And also, Your Lordship will see that 309 is a case of robbery, Your Lordship.
The item mentioned.
Lordship, may I know?
Yes.
Lordship, here the alleged accused is a advocate by profession. What has happened, Lordship? What he has done, Lordship? He actually went there with as called by the.
Was he practicing here?
He's practicing here, Lordship.
Then
And Lordship,
it's more
he went-
difficult, it's more difficult.
Yes, Lordship. But Lordship, what has happened?
The advocate going for such joining such group.
No,
becomes
Lordship,
more
he has went
difficult.
there to state that whatever the
It will be more difficult for him then, in that case.
He had went there, Lordship, to say that since there is a defamation, that there is a defamation case against the complainant, which he had made a viral in the social media, saying that, in fact, Lordship, here the man whose name is taken, he was never arrested by the police station. What is that? There was an NBW issue against him in connected with a check bounce case, Lordship. He had appeared on that day. He had appeared on that day. He had made the payment. As soon as he came out from the court, there was an photograph of him saying that Mr. So-and-so has been arrested by the.
What is this? Where is the rejection order?
The first rejection order is, Lordship, page 25, Lordship, by the
Page 25
Lordship.
is by, this is
By the
by
Honored JMFC.
judicial magistrate.
What's
27.
rejection?
And then the second,
No,
Second-
24.
Bill rejection is 25. And the second is on page 27, Lordship, 19/7.
27 is a rejection order.
Vice Lordship, by the district and session judge.
What is this? The accused shall appear before.
There were two persons who were arrested in this.
Okay, one was released
One was released. One.
and the case of the petitioner. This was recently only. What?
No, Lordship, it's a. Lordship, here, I like to page 24, Lordship, on the 36th of 2025 itself, the IO said that. May I, Lordship, page 24, Lordship.
What is this 24?
When they were produced before the learned JMFC, Lordship, 8 paragraph.
Yes,
Lordship.
it's
May I
applicable. This is production order.
Yes, production. On the production order on 36th of 2025, Lordship. This was on July, Lordship. It says, Lordship, may I, Lordship, seen that IO has spread to remand the accused person to judicial custody as they are no longer required in police custody. Lordship, here on the 36th of 2025 itself, the IO has.
What is the observation in the rejection order? Stolen item.
Rejection is at page number 28, para 7, Your Lordship.
Okay, Mr. Jam. Direct counsel for a petition. Also have Ms. Cheney, learned additional PP for the stage. So I'll pass order, bail rejected.
Lordship, may kindly consider here, Lordship, the other accused person has been granted the law only term and condition, Lordship.
Maybe. I've seen the record.
Since Lordship, it's a 40 days, the main accused whose name has been.
Maybe. Okay, next.
Obliged.
Please, Your Lordship. Lordship, this is a pre-arrest bail, Your Lordship. On last occasion, Your Lordship, this honorable court has called for case diary. Item 10. This is a pre-arrest bail, Your Lordship.
Lordship, we have not received the case study, Lordship.
Not yet.
No, no case study we have not received yet, Lordship. Yes, Lordship, we tried to communicate through the telephonically also, Lordship, but there's a network issue is also there.
Your Lordship, I have one prayer, Your Lordship. If Your Lordship allows me. Here in this case, Your Lordship, most of the sections mentioned in the where is the FIR? It's page number 18, Your Lordship. May I read the FIR, Your Lordship? With due respect, I would like to inform you that one Sri Taring Nalo, son of so and so, a respectful citizen of Damba village under POPS Talia. Today, on the date of 3rd July 2025, a person known as Tagio Nalo, son so and so, he came to my house, trespass and attacked my tenant with a dao. And when I tried to stop him, Tagio Nalo started hitting me. So in self-defense, I have to clash with him back. Therefore, it is kind request to your department to take necessary strict action against BNS so and so. Your Lordship, if you see the section, Your Lordship, most of the section are valuable in nature, except section 118, Your Lordship, subsection. What is that 118? It's talk about the voluntary causing hurt or grievous hurt by dangerous weapon or by means, Your Lordship. However, in this section, Your Lordship, what is 115? 115
causing hurt.
115.
The voluntary causing hurt.
BNS. Section 115, subsection 2 is talk about the voluntary causing hurt, Your Lordship, and it is valuable in nature, Your Lordship. And regarding the section 118, subsection 1, the voluntary causing hurt or grievous hurt by dangerous weapon, this is only non-valuable. And moreover, Your Lordship, even under this section, the maximum punishment is up to the 3 years or with fine, Your Lordship. But earlier, while moving the bail application, it was not granted. We'll wait for them. Your Lordship, I have not prayed before the court regarding the interim bail, Your Lordship. Last time I did not pray for the interim bail. You did not pray? Yes, this time I'm praying this. If I'm ready to cooperate with the investigation, Your Lordship. Why this time you are praying? Why? Because Your Lordship, what situation has changed? Your Lordship, I have a wife, a child, and old age parents, Your Lordship. There you did not have wife? No. Huh? So, Your Lordship, I'm ready to cooperate with the investigation, including no. And if we see the section, Your Lordship, it's not a great nature of offenses. You are Mr. Tigam, Your Lordship. None counsel for the petitioner. Miss L. Hagia, none additional PP. So, which PS?
Lordship,
Talia PS.
Taliha.
Zaporizhzhia.
Lordship, this network is also a way of telephonically, Lordship, tried to communicate. We have already sent to WT message for the case study, Lordship. That itself
have they received? Have they received?
No, Lordship, we have not received any communication. We have not received yet. Lordship.
No. Have they received?
Yes, Lordship. We have sent from our Lordship. Yes, Lordship.
Addition PP, some mistake, although this was you asked for the case diary.
No,
So we need to call for the scan copy,
yes, Lordship.
and it appears that case diary was called for. We'll say scan copy,
Yes, Lordship.
okay? Raise for some more time to produce a case diary. So call for the scan copy of the case diary. So list this matter again on 11 August. 11.
Lordship.
Okay.
Okay.
Much obliged.
Please, Your Lordship. This is for the suspension of sentence. We have filed one additional affidavit.
Item 12.
Item 12. Filed an additional affidavit. The lady, my lord, she's 65 years old. She is undergoing treatment at AIMS. Sorry, my lord, at TRIPS.
So well, this is appeal,
A criminal appeal.
criminal appeal.
Criminal appeal. There's
The
an IA for suspension. of
Convict.
sentence. Convicted. 10
For
years.
how many?
10 years. my lord.
10 years.
10 years.
For offense,
Offense NDPS, my lord.
NDPS.
NDPS. However,
The
in a-
record must have been called for.
record was called for, and lordship, there are other two appeals of two other co-accused.
Okay.
In them, my lord, the
Already-
TCR was tagged with.
Hmm?
The TCR was tagged with. I've requested the registry to produce the records, and they have come here.
Then paper book already prepared.
We have not got here till now.
So here in this case, also with regards to the present case, paper book need to be prepared. I think if the TCR is.
We have not received anything, my lord. TCR also, your lord, is not reflected in the cause
So
list. my lord.
it's there with the other two cases.
This is in the same case.
Same case. Same case.
Different accused.
Different accused, different appeals. There are three appeals.
All the document probably in the, because it's
Yes.
entire TCR repair, so
Will
it
be
must be
there.
same only.
It must be same. But
Then,
it has to be the
then more copy of this
Yes.
need to be,
Yes, furnished to us.
and then to be furnished to the respondent also.
So, your lordship, there's a certain development, my lord.
Hmm.
I'm praying on the ground of medical requirement, my lord. Your lordship will come to my additional affidavit. Then additional affidavit filed on Thursday.
10 years, how long you've been there inside?
My
Till
lord,
now.
the
After
judgment,
conviction.
my lord, is 23/4/2025 and sentence 28/4/2025. No, my lord, I have just undergone an operation. I'm 65 years old. I have annexed all the medical documents. Operation in TRIMS. I was admitted on 23rd of July. And still,
Normally it's a duty of the jail authority to look after.
yes, yes.
So
your
there is a provision.
Yes, your lordship. But in the jail, her treatment could not be done. That is why she was shifted.
Now the jail will be, the jail authority will be called then.
Lordship, the fact, my lord.
Because the order need to be passed against the jail authority. If the jail authority is not doing, then the higher authority will
No,
have to
but-
be directed.
My lord, the jail authority has shifted her to TRIMS.
So that is why I'm saying, jail
My-
authority, if they can't, because if the person, the convict cannot be treated
My lord,
in the jail,
my lord.
then they are bound to sit to TRIMS.
Yes.
Or to any other hospital with
Lordship.
all those facilities.
Lordship.
It's the
Lordship.
duty of the state.
Lordship, she has been shifted and she was operated on 1st of August.
Mhm.
The operation was done, but she needs some treatment. Your lordship, in the other two appeals, the sentence has been suspended. The reasons are given. If your lordship kindly takes
In
some
other two appeal,
other two appeals.
in the same case,
Same case. Same case.
sentence suspended.
Sentence suspended. Your lordship will kindly come to the.
So they were
office.
also convicted for 10 years.
They were convicted for 5 years. For
Okay.
5 years. But the reasons given.
You are main accused,
We are three of the accused, your lordship. And
but you are main accused.
lordship, the contraband
Hmm.
was recovered from the room of my driver. There is no direct.
Whether
evidence.
driver was convicted?
Driver has also been convicted.
Okay.
But
Your driver.
my
See,
driver.
it's your driver.
My driver.
Hmm.
And your lordship, the statement of the driver
Hmm.
was relied upon by the trial court. However, it was not admissible in evidence. That is one of the main grounds of my appeal. Your lordship may kindly come to the additional affidavit. Just for a moment, for my satisfaction.
Hmm.
May kindly come to page 180. The reasons given.
118.
180. 180.
180. 180 is there.
Yes, Lordship. In the additional affidavit. Date of filing. Additional affidavit. Date of filing. When was it filed? Huh? It was filed on 31st
This
of
appeal has been filed by the convict.
Convict.
Convict herself.
Convict herself.
Okay.
Additional affidavit is by her son. 100 starts at 181. Similar orders in two of the other suspension of sentence IAS. Lordship, page 181. Lordship may come to para 4. The prosecution case, Lordship finds
81.
181.
81 would be
181. Of the additional affidavit filed on 31st.
181.
181.
So it's 180. Para 4 is at 180.
Para 4.
Start with the prosecution.
Yes, Lordship.
180.
Oh, sorry, Lordship. Sorry,
180.
Lordship. In my page, it's different. I'm sorry, Lordship.
Okay.
Should be 180. Lordship, the prosecution case, as is revealed from the FIR lodged by the SDPO Itanagar, dated 31/3/2018, is that upon information received from reliable source, a search and raid was conducted on 31/3/2018 at different locations of Itanagar and Nahalagan area, and during the search, huge quantity of ganja were seized. It was further stated in the FIR that the appellant, along with 4 others, were found indulgent in selling ganja in the capital complex area, not me, Lordship, and they were detained in pursuance thereof. The learned trial court, on conclusion of the trial, had convicted the appellant on the ground that that in pursuance to common intention and criminal conspiracy with the other co-accused, the appellant was found selling ganja to addicted persons from her shop, as the same was recovered from the said shop of the appellant. The learned trial court also held that the appellant, along with Srimati Noori Yai, used to sell ganja from their shop, and that on 31/3/2018, intermediate quantity of ganja weighing 3 kgs were recovered from the shop of the appellant, and as such, the offence under section so-and-so of the NDPS Act was meted out. Mr. So-and-so, learned counsel appearing for the appellant, has mainly based his argument on the ground that the contraband recovered from the appellant was not proved to be ganja, as per the definition of ganja in NDPS Act 1985. He has placed definition of ganja enumerated in section 23B of the NDPS Act, which is reproduced here in below. Ganja, that is the flowering of fruiting tops of cannabis plant, including seeds and leaves, were not accompanied by tops by whatever name they may be known or designated. Mr. So-and-so, learned counsel for the appellant, has placed the FSL report dated 26/4/2018, which was exhibited as Exhibit 11, wherein it was described that the contraband was dark greenish colored dried plant substance with seeds and leaves stated to be ganja. He has also placed the deposition of the junior scientific officer of the Central Forensic Science Laboratory, Guwahati, who had deposed as PW7, and he stated that he subjected the samples to chemical test and found the samples positive for cannabis. Mr. So-and-so states that the junior scientific officer of CFSL did not clearly state as to whether the contraband sent for testing was charas, ganja, or indica mixture. He stated that cannabis, as such, the contraband was ganja in its proper definition, or it is some other material. Mr. So-and-so, learned counsel for the appellant, has also placed a judgment delivered by the Honorable High Court of Karnataka in Rangappa versus State so-and-so, reported in 2022 Supreme Karnataka 467, wherein it is stated that the contraband, which is stated as ganja, should not include seeds and leaves. Mr. So-and-so, learned counsel, also says that appellant has 2 minor children, so this lordship may skip. 11 is, on the other hand, Mr. Tado, learned APP, states that the paper book is ready, the matter can be taken up for final hearing. He also states that the matter relates to recovery of contraband under NDPS, which is a menace to society, and as such, the appellant should not be released on bail or sentence should not be suspended. I have heard so-and-so, para 13. From the definition of ganja, as shown by learned counsel for the appellant, it is clear that ganja includes only the flowering of fruiting tops of cannabis plant, which again should not include the leaves and seeds. In FSL report, it is stated that the contraband is a dark greenish colored dried plant substance with seeds or leaves. On prima facie examination, it does not reflect that there are flowering of fruiting tops of the cannabis plant. The FSL report also shows that the seeds and leaves are also present with the contraband seeds, which is again, in view of the definition, cannot be included in ganja. Further, the FSL report, it is stated that the contraband, which is stated to be ganja, cannabis, without any further clarification as to whether it is ganja or it can be charas or any other mixture, whether the junior scientific officer of CFSL stated that it is cannabis. However, the said aspect should have been raised during trial, and the junior scientific officer of CFSL should have been questioned by the defense. There is nothing on record to show that there was any cross-examination on the point as to what contrabands were seized from the appellant. The same cannot be agitated at this stage. However, the learned counsel appearing for the appellant has stated that the instant ground being a law point can be raised at any stage of the proceeding, and since this appeal is a continuation of the criminal proceeding, he has taken the said ground before this court. Further, the ground that the appellant has two minor children, that two in number, is to be considered. Further, the appeal is registered in 2025. The appellant is sentenced to 5 years incarceration. It is noticed that the appellant has been inside jail since the date of the sentence. It is also the hearing of the instant appeal will take some time. As such, this court suspends the sentence. This is the
fact. This is in which case?
Out of the same judgment, co-accused.
Out of the same judgment.
Co-accused. And another, my lord, from page 180, from the next page, my lord.
So the report regarding the ganja is?
It is the same report.
Same report.
Same report. And similarly, my lord, from the next page onwards, another criminal kill of another co-accused. The same contents. Same contents.
Same order.
Same order. Same contents. Lordship, in my case, this is one of the grounds, my lord, I would pray for parity. And along with that, your lordship, my medical statements I have annexed. Medical statements from TRIMS. There was another additional affidavit, my lord, filed earlier, wherein I was taken to TRIMS for treatment. That was in the month of June. But since my health deteriorated.
So who was this another? One was driver and the other was?
They were selling. These two accused, they were found selling the contraband.
Driver and the?
Not driver. These two are the sellers. These two are the sellers.
To whom?
The alleged sellers.
Okay.
Alleged sellers. It's the same report which is there in my case. It's the same exact. It's that very same report.
Yes.
And Lordship, just another aspect. Your Lordship may come to page 105. It's the correct page initial. Page 165. It may be 164. It's a Tomoriba Institute of Medical continuation sheet. It's a letter to the consultant or DOD of Department of Medicine TRIMS by the treating intern. Lordship, this is the page edition. Lordship. Respected sir, madam, hereby referring you a patient, Yowa R.A., 65-year-old female. She is a known case of chronic hypertension and on and off nature, 3 to 4 reading in a day. In normal, with her reading is high. She is non-compliant to medication. We are planning for vaginal hysterectomy with spinal anesthesia for UV prolapse. Then, my lord, the other note sheets and the treatment documents are there. Then again, my lord, may come to page 170. It will be 169. I'm sorry, my lord. Yes.
169.
169. My lord will see the plan. There is an underline. This is on 30th of July. Underline plan vaginal hysterectomy on 1/8/2025. This was done and she's still admitted. Well, these are the terms.
Kindly come here, your lordship. They have made an interpretation of ganja and they have stated that the contraband substance whichever has been recovered is doubtful, your lordship. That was the plea in the earlier two cases, your lordship. Now, your lordship may kindly see the definition of ganja. Two, my lord. Definition is in 2, subsection 3, clause B.
Yes.
May I read, your lordship? Ganja, that is the flowering of fruit top of the cannabis plant, excluding the seed and leaves when not accompanied by tops. Meaning thereby, your lordship, if seed and leaves are there, but it is not accompanied by the top, then the seed and leaf will not be considered as a ganja. But when it is accompanied by the top,
then it will be come under the definition of ganja. So here, the main issue, main aspect to be considered in the material is the flowering top. This section doesn't say it should be the flowering top only. It says seed and leaf will be excluded where top is not there. But when top is there, the both will not be excluded, my lord. And this issue, your lordship, has never been put before the trial court during the trial. The forensic expert has clearly stated that it is a ganja and they have not crossed it. Now, your lordship, section 58 comes, if you fact admitted need not to be proved. Now, at the appeal stage, now they simply come with a ground that it was not proved. You have never assailed it when it is said it is a ganja. When it said ganja, ganja definition will automatically come, your lordship. The presumption will come. And now, your lordship, the second part which has been missed out is, your lordship, I kindly see the section 32A of the NDPS Act, my lord. The earlier one, now it has been held unconstitutional, but the guidelines have been laid by the Supreme Court. What aspect has to be considered for even suspending a sentence of the NDPS Act, my lord? 32A, my lord. Yes. May I read, your lord? Section 32A. No suspension, remission, or commutation in any sentence awarded under this act is a general for every act, your lordship. Notwithstanding anything contained in the Code of Criminal Procedure 1973, 2 of 1974, or any other law for time being enforced, but subjected to the provision of Section 33, no sentence awarded under this act other than Section 27 shall be suspended or remitted or commuted. Now, these sections come before the Honorable Supreme Court for consideration, your lordship. Your lordship, the discussion made by the Honorable Supreme Court, which was reported in 2000, volume 8, SCC 437, Dadu alias Tulsi Das versus State of Maharashtra. Even for your lordship, post conviction, your lordship, also your lordship, section 37 condition has to be fulfilled. They have to satisfy this code. The two twin test, your lordship. Citation 2000, volume 8, SCC 437. Now, the definition part is clear, your lordship. Now, your lordship, para 29, my lord. May I read, your lordship? Under the circumstances, the writ petitioner disposed of by holding that Section 32A does not in any way affect the power of the authorities to grant parole. 2. It is unconstitutional to the extent it takes away the right of the court to suspend the sentence of a convict under the Act. 3. Nevertheless, a sentence awarded under the Act can be suspended by the appellate court only and is strictly subject to the condition spelled out in Section 37 of the Act as dealt with in this judgment. Now, Section para 30. The petition in writ petition number so and so shall be petitioner in writ petition number so and so shall be at liberty to apply for parole, and his prayer be considered and disposed of in accordance with the statutory provision, if any, jail manual or government instruction without implying Section 32A of the Act as a bar for consideration of prayer. Similarly, the petitioner in writ petition number so and so is the liberty to move the High Court for suspension of sentence awarded to him under the Act, as and when such an application is filed, the same shall be disposed of in accordance with the law and keeping in view the limitation prescribed under Section 37 of the Act and law laid down by this court, your lordship. Now, even post-conviction, your lordship, Section 37 twin test has to be complied with, your lordship. And your lordship, recently, your lordship, this judgment has been reiterated, where it again, your lordship, the Supreme Court has held this, despite there is an embargo under Section 37. If, your lordship, the accused is incarcerated for a period, the substantial the part of his substantive sentence, your lordship, then in such case, the court has to take consideration of Article 21, because your lordship is well aware that appeal is deemed to be a trial. And if it is a trial, then speedy trial is a right of the accused, your lordship. So if it is delayed, unduly delayed, and not in the part of the accused, then court can no doubt suspend the sentence. But here in this case, your lordship, recently only they have convicted, your lordship. And if, your lordship, the appeal of the accused is not likely to be heard, before he undergoes for the entire period of sentence. Then in such cases, your lordship, the sentence can be suspended, your lordship. This is the recent judgment, your lordship, wherein the Dadu case was reiterated, your lordship. Narcotic Control Bureau versus.
Not the report, not the report. Yes.
There's a 2000 equivalent citation 2025 IMSC 190. Para 7, my lord. This is Narcotic Control Bureau versus Lakhvinder Singh, my lord. Para 7. This is the exception to section 37, your lords.
Yes.
Para 7. At this stage, the learned ASG appearing for the petitioner submitted that the power of the court was constrained by section 37 of the NDPS Act, which is applicable even at the stage of an appeal. He relied upon a decision of this court in the case of Dadu versus State of Maharashtra. There is no dispute the fact that appellate court is bound by constraint of section 37 of the NDPS Act while considering the prayer for grant of bail during the pendency of an appeal. However, if in the fact of the case, an accused was undergone a substantial part of the substantive sentence and considering the pendency of the criminal appeal, his appeal is not likely to be heard before the accused undergoes the entire sentence, the appellate court can exercise the power releasing the accused on bail pending the appeal. If the relief of bail is denied in such a factual situation, only a ground of section 37 of the NDPS Act, it will be amount to violation of the right of the accused under 21 of Constitution of India. Now, here in the present case, your lordship, this will also not apply because she has not underwent for a substantial period of incarceration, your lordship. So this judgment will not apply in his case. But the section 37, the Dadu matter will apply in his case. And so far as your lordship, the medical treatment is concerned, it was not from the side of the state who has prayed for the court for release of the accused because the state is not in the position to give advanced treatment. It is their plea that the state, they want to be, the accused should be released because she is under treatment. But the treatment has been looked after by the state government only, your lords. So that cannot be in fact a ground for suspending the sentence, my lord. And so far as you do two judgment, whichever the learned senior brother is, your lordship, relied, your lordship, even in that aspect, your lordship, the parity for parity, it has to be considered whether there was other antecedent against the accused or not, your lordship. That is also to be looked into, your lordship. And here, your lordship, in the present case, which my learned senior is relying, your lordship, there, your lordship, section 37 was not taken into consideration. Although it's a mandatory, it is the judicial pronouncement, my lord, wherein the section 32A has been held unconstitutional. So, my lord, this at this stage, your lordship, this honorable court may not interfere with the sentence, the suspension, interfere wise.
It appears that the paperwork has already prepared.
Yes, your lord.
Since it is, so same copy will be made, copy will be served and we'll try to dispose of it as early as possible.
Your lordship, it has to be, that is one aspect, but the present condition and my lord, what my learned friend, the PP has submitted about section 37, my lord, section 32A in the judgment of Dadu has been held unconstitutional and said that section 37 has to be complied with. What does section 37 say? If my lord takes up section 37,
yes.
my lord, offences to be cognizable and non-bailable. 1. Notwithstanding anything contained in the Code of Criminal Procedure 1973, every offence punishable under the Act shall be cognizable. B. No person accused of an offence punishable for offences under section 19 or section 24 or 27A, and also for offences involving commercial quantity shall be released on bail or on his own bond unless 1. The public prosecutor has been given an opportunity to oppose the application for such release, which is satisfied. Number 2, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and is not likely to commit any other offence while on bail. The limitations on bail specified in clause B of subsection 1 are in addition to the limitations under the Code of Criminal Procedure or any other law for the time being enforced for granted. Lordship, in this case, what I'm praying for, Lordship, is the present situation. It could be an interim bail, for a limited period of time, because the coordinate bench of this honorable court has found that there is some doubt as to the identity of the controversies and whether the persons could have been convicted. There is a doubt which has been judicially expressed. After such doubt, and I statement of the learned PP that it's a wrong judgment or wrong order, that will not be considered, Lordship, because that may not be proper. It's an order, a judicially pronounced order of a coordinate bench. Until and unless the appeal is decided, that order which reflects clearly the doubt in the mind of the court, of the appellate court, my lord, that needs to be examined. So therefore, as of now, my lord, there is a doubt whether these persons could have been convicted at all. When that is there, my lord, section 37 is satisfied. The first part, opposition by the PP, the learned PP has vehemently opposed, which he always does, very fairly, my lord. Second part, the doubt. That doubt is here. Thirdly, my lord, parity. Fourthly, my lord, the health condition of the 65-year-old lady. And it is not untrue. It is not a figment of imagination that she is unwell. She is ailing. The doctors there say that she is not responding to medication. Lordship has read that letter. She is not responding to medication, for which Lordship knows the condition in the jail. If she is now shifted to jail, her life will be at risk. Not from anyone else, but from her health condition. That is why, Lordship, what I'm praying for is for a limited period of time. Limited period of time.
So that,
with the most stringent of conditions.
that means you are seeking parole.
Parole, Lordship. For a parole, Lordship, or suspension of sentence, whichever, my lord, so that
it won't take much time. So the entire appeal will be disposed
but
of.
at the moment, Lordship, at the moment, because she had undergone the operation on 1st of August.
It's conviction.
Conviction, my lord.
That is,
but
that is
at the,
different. That is different.
that I understand, Lordship. But at the same time, my lord, Lordship will also consider that she has undergone operation on 1st of August. That is why, my lord, this hearing, my lord, though it will not take much time, my lord, but it will not be immediate. As of now, if her health, my lord, since she is not responding to medication, taking that into aspect, my lord.
That the state will report.
My lord, if she loses her life, that is what I'm concerned about.
Now,
that is why the son has,
if it comes, the state will report, the police will report.
my lord,
It will be difficult.
my lord, that report may also be called for from TRIMS.
Now, see,
my lord.
in the NDPS case,
I understand.
and under the circumstances where there is a clear evidence.
My lord, there is no clear evidence. Actually, my lord,
There is.
my lord, because, my lord, of the fact, my lord, it was
So-
not recovered from her possession. There is no evidence linking her.
So that is why we'll try to expedite the disposal of this appeal.
My lord, that I would humbly pray, yes, my lord, that I'm all for it. But for the time being, my lord, just for the time being, so that her health could, just for a limited period, or this could be kept pending also, Lordship, just for a limited period of time, so that her health could be considered.
Now,
With the
what we
most
do is
stringent of conditions.
only the authority can be directed to take care of her, to give the treatment, give all necessary treatment.
My lord, the treatment she's getting, but she's not responding, my lord. And she needs,
No, if she
needs good
if she is
food.
getting treatment,
My lord, treatment in TRIMS, my lord, she's still admitted.
then what more you want?
My lord, the care of her, my lord, of her son, my lord, and food, my lord, that food portion, because for her to recover, my lord, she needs, her immunity is compromised. That is reflected, my lord, in the TRIMS documents. My lord, it is after 3 weeks that the result will arrive from whether the surgery has been successful or not. It's for, my lord, at least for that period of time, for a limited period, for a very limited period. So let's can recover. At least for her treatment, Lord.
No, if you are asking for a treatment, then it's a parole only.
But my lord may consider that aspect as well, my lord. My lord has the power, my lord. For this very limited period. And if in the meantime, my lord, if it is heard, well and good, my lord.
I'm not in the, and especially in NDP's case,
My lord.
and then. No,
And my lord, another aspect your lordship will consider, my lord, is that why is this embargo placed on restricting suspension of sentence? My lord, so that the person cannot indulge in such offences. In her health condition, my lord, she will not be able to do anything.
we are not expert.
My lord, the documents of Prince, my lord,
Maybe,
the
maybe.
surgery itself, and the letter from the doctor to the internal document of Prince itself, my lord. It's not my statement, my lord. It's the statement of the doctor that she is not responding to medication. Page 100 and my lord, page 164, my lord.
No, Mr. Nair.
My,
So if at
Well,
the moment I'm not inclined
I-
after
my
on
lord.
perusal of the record, but then if it doesn't improve, later on if changes, if it is going to take longer time, we'll try to consider next.
Or could I suggest another aspect?
Hmm.
If my lord could call for a report from Prince. From Prince, my lord. And
You have
lordship
produced,
can,
you have produced the entire record in here.
my lord, we have, but the report, if lordship requires that, if for consideration whether after some time, if lordship could take it up, my lord, not today, with the report, my
No,
lord.
because you see the paper book already prepared.
Yes, lordship.
So the next time if we fixed, today it is listed for
For orders, my lord, on this IA.
orders. Then the parties are present. If the copies, this only the copy need to be,
Copy need
no
to
need
be
to prepare, no need to prepare over and again. Only
Right.
copy is to be
My
made out of this.
My
It won't take much time. So
My
what
lord.
we'll do is we'll fix for the final hearing.
My lord, that would be good, my lord.
Not before that.
My lord,
Release and
till that time, my lord.
Had it been the bail
My lord.
in the case where
Pre-conviction.
before
I understand.
that's different. But then after conviction, it's very difficult,
I
and then
understand.
it will proceed.
The commercial quantity aspect, I understand.
Yes, that is right.
But whether the doubt
Very
itself,
difficult.
which has expressed by a
We
coordinate
should
bench.
also care about the society also,
My lord, I understand.
and then everybody knows what is going on, and
I
everybody expect the court to at least to to deliver the justice.
I understand.
And then the court properly deliver justice. And if the High Court on the prayer in the after conviction is done afterward, after the entire trial of the cases, exhaustively trial of the
But what I would say
now the observer could understand this, but then let us see the trial will just bring it out.
Lordship, then could I pray for expedited hearing, my lord? Could I pray for expedited hearing?
That is why the copy will be ready. Copy, since it is ready, only the Xerox copy is to be made, probably.
Yeah,
Now
yes.
they don't have to prepare
Yes.
entire paper books.
Yes, yes.
So paper book, since it is ready, only the copy need to be made. So
Yes.
it won't take time.
Lordship.
Mr. P. Nair, land counsel for the applicant. Applicant, huh? Stop. Also hard, Mr. Then additional people started. It is submitted that the paperwork in connected case has already been prepared. The registry is directed to prepare a copy of paper. How many copy would be received?
Lordship, perhaps three copies.
3 copies. The
Yes, 3
registry is directed to prepare 3 more copies of the paper book and furnish the same to the parties within 3 weeks. Okay?
Okay, Lordship.
Okay. List the matter after furnishing the paper book.
Yes, sir.
List the matter immediately after furnishing the copy.
Yes, sir. And
of
your
the
lordship
paper
will make
to the parties.
query of that issue also. If she is not fit or she is referred to the out of the state, then your lordship definitely will come with the affidavit, your lordship.
She has referred, been not yet.
Not yet referred.
Okay,
Should may also call for the for a report.
Record may not be required now because your record is there, already there. Because what I know is the jail authority, if it goes beyond their control, and if they, because every time they used to monitor, and if it goes beyond, they report it to the court only. And then with that report, I think that then, of course, you will have
Yes.
a better case.
Yes. Lordship, there are two other criminal appeals arising out of the same judgment.
Okay.
When next the copies, Lordship, it is criminal.
Okay, this, no, arising out of this same.
Same criminal
No.
appeal 11 and 10 and 11 of 20.
In that case also the paperwork not yet prepared.
This is the same paperwork. This is
No,
the
no, no,
paperwork
no, in that case also, order was not there for preparing a paperwork.
Order was probably there. Order was there.
There was.
Order was there.
Okay,
Order was
you want that matter also to be listed along with
Because
it.
since it arises out of the same judgment, as per the High Court rules.
So that also to be
together.
listed along with this present appeal. Okay, list this matter after 4 weeks along with the give number, criminal appeal number
10 and 11 of 2025.
10,
10 of 2025 and
criminal
11 of
appeal number 10 of 2025 and
11 of 2020.
11 of 2025.
11 and
Okay.
12. No, 10 and 11. 10 and 11, not 11, 12. 10 and 11.
Okay.
Lordship, could I pay for a date, Lordship? Because since it
No,
is.
no, see, the paperwork now shifting is going on and then it might take a little longer time. So that is why I'm saying. So that will be difficult. Let them prepare the paperwork and immediately after preparation of paperwork, they list it. Okay.
Then instead of 4 weeks, immediately after preparation.
Okay,
As
I will
Lordship has
ask,
said.
leave the 4 weeks. Okay.
Obliged.
Deeply obliged.
It's already 1 o'clock now. I will,
Oh, now,
I will take half an hour, that's why.
okay,
This
then,
matter is
at 2,
at 2.
what is this matter otherwise?
It is listed for my consideration of interim prayer, your lordship.
Interim prayer.
Interim prayer.
This is criminal petition.
Criminal petition, my lord.
What is the offense involved?
My lord, may I submit, my lord?
Yes.
My lord, I petitioner before your lordship is, my lord, 2003 batch IS officer, when she was posted in the year 2007-8 at West Kameng Hill, Kameng district, Bondila, my lord. What happened, my lord? Due to, my lord, since engagement ceremony of the petitioner sister, it was going to be organized, and so petitioners, guests, my lord, in-laws all came to Bomdila, and because of some reason it was not materialized. So whatever the amount they brought to petitioner's place, petitioner sent back to that amount by way of bank draft. But at the time of giving for bank draft, he has given to her staff. Because in DC office, my lord, if it is done by DC office, then they don't charge, my lord, bank draft commission. When she came to know that bank commission was not given because it was her personal capacity, personal, so she has paid bank draft commission also. At the relevant point of time, my lord, a departmental proceeding was initiated against petitioner on this allegation itself by Ministry of Home Affairs. That was challenged before, my lord, learned CAT of Principal Bench, Delhi, your lordship. I will come, your lordship. I will refer the document. Honorable CAT Delhi, my lord, has quashed the proceeding on the ground that MHA has no jurisdiction and authority to initiate departmental proceeding because it was done in the state of Arunachal Pradesh. It is the state of Arunachal Pradesh who can, my lord, initiate departmental proceeding. Against that, your lordship, CAT judgment, Department MHA preferred writ petition before Honorable.
What is MHA?
MHA, Ministry of Home Affairs, my lord.
Okay.
So Ministry of Home Affairs
Okay,
prefer. I will place, my lord, all the judgment and everything, my lord, all the documents. Just I am giving, my lord, synopsis so that your lordship may.
What is the stage of this case?
Charge, my lord, they are going to frame charge.
Already submitted.
Charge sheet already submitted.
Another section.
My lord, sections
What
are.
offense?
My sections are, my lord, 120B, 420, 109, 477A. Read with section 13, subsection 2, section 30.
Which court?
My lord, by
which court?
UPIA, Special Judge UPIA.
Okay, then so.
So I am praying for by this criminal petition, I am seeking, my lord, quashing of FIR, charge sheet, prosecution sanction granted, against me, and my lord, the order taking cognizance.
Okay,
So
already-
I will satisfy my lord
When the next day is.
on 15th of September, but my lord, before that, my lord, what happened?
15 of
15th of September.
September. Why don't you try there?
My lord,
At the-
because
at
this
the-
is a case
at the-
where,
at
my
the
lord,
time of framing charge, why don't you?
my lord, I'm
an
not on
application
that.
for
I'm not on that. I'm coming, your lordship.
Yes.
My lord, entrustment of CBI investigation, it can be done either by state government or by High Court or by Supreme Court. In the present case, MHA has suo moto taken over that investigation from state of Arunachal Pradesh to CBI and transfer it to CBI. It is violation of section 17 capital A. Prosecution sanction, your lordship, can only be granted by the state where the offense has taken place. This is violation of section 19 of my lord PC Act. My lord, so far as my lord PC Act are concerned, my lord, sections prosecution sanction was granted by a authority who is not competent.
Why don't you raise this before the trial court? At the
Because
time-
trial court has already taken cognizance. I'm challenging it, my lord. Why I will take before that when the
Where you given an opportunity?
my lord.
Where you given an opportunity there?
My lord, it is not why that's why 482, my lord, because my life and liberty is there. Why I will face trial for the offense which has been initiated by the authority who is not competent, who is not authorized to do it. It has been done, it comes from a trenching upon a power which is given to state of Arunachal Pradesh by MHA. I will satisfy, my lord. I have annexed all the documents. I have Apex Court also says when the prosecution sanction is granted by a authority who is not competent, the entire proceeding is vitiated. Well, why I will go there, my lord, for facing trial when the entire proceeding is based on prosecution sanction and section 17A and violation of section 19. My lord, it directly hit, my lord, the very foundation of the case, your lordship. So, my lord, at 2, my lord, I will satisfy your lordship.
To continue it.
My lord, my lord. Deeply obliged, my lord.
Item number 13 to 20, my lord. Connected matter, my lord. Service is still awaited, my lord. So, petitioner.
Lordship, I may be allowed to make a fresh state by in the form of dusty service, Lordship, as well as an interlocutory application and as an amendment revision petitions.
Item 13 to 28, my lord. Connected matters.
You want to take fresh steps?
Yes, first in the form of
Your
dusty
form?
service.
And for the state, my SIT, my lord.
Okay. You're for the applicant,
Yes, Lord.
Mr.
G.
Direct counsel for the. Just a minute, sir. Your G?
G. Ubin.
Okay. In view of the office note dated 31/7/2025, the direct counsel for the applicant prays for allowing him to take fresh steps upon the respondent. Number 2.
3, my lord. 2, yes, my
Yes,
lord.
respondent number 2. Yes, respondent.
The prayer.
Maybe alone in the dusty service.
The prayer, okay, take fresh steps upon the respondent by way of dusty service. Stop, the prayer is allowed. Dusty service on the respondent number 2 to be routed through the registry of this court within 2 weeks.
Yes, Lord.
And file affidavit to that effect. Okay. Mr.
El Kurdu, my lord.
Okay, Kurdu, Lanet,
SPP, SIT.
Standing counsel.
SPP, my Special Public Prosecutor.
Okay, Lanet, SPP, Special Public Prosecutor is also present. Stop. Okay, list is matter up, sir.
5th September, Lordship.
5th September.
Yes. Because we have a similar matter pending before.
Okay, age break for comma, list is matter on 5/9.
Yes, Lord.
Okay.
Lordship, dusty service in
This
the
is-
interlocutory application as well as the revision petition, then revision petition.
Hmm?
Dusty service may be allowed as well as in the interlocutory applications and then revision and petitions.
Okay, enforced. Okay,
Obliged.
this is item 13 to
28.
28, Lordship.
Obliged.
May I start, your lordship?
yes.
My lord, before referring to documents, my lord, when I was posted in 2007, as a Deputy Commissioner of my lord West Kameng District, my lord, a departmental proceeding was initiated by Ministry of Home Affairs against me. Side by side, my lord, is in a state of Arunachal Pradesh, an FIR was also lodged where I have not been named in the FIR. That departmental proceeding, my lord, was challenged before Central Administrative Tribunal, Delhi. Central Administrative Tribunal, Delhi quashed the proceeding on the ground that MHA has no jurisdiction and authority to initiate departmental proceeding against the petitioner as the incident is in respect of the service in respect of the affairs of the particular state, that is state of Arunachal Pradesh. Now I am taking your lordship to the judgment rendered by on learned cat Delhi. Page 220, it starts from. And the relevant page. Para 28, 27, page 262. And I am taking your lordship to next page, 263. And line number 8 from bottom, your lordship, it starts as noticed, 263, my lord. 263, my lord.
Page number?
263. It starts from 220 and relevant page is 263.
Yes.
It starts from as noticed. Your lordship has got it.
263.
263.
Yes.
Second line, it starts from as noticed here in above. Under rule so and so of 1969 rules, it is the state government of the state where the applicant is serving in connection with the affairs of that state and a constituent of the joint cadre, which is the competent authority to institute the departmental disciplinary action and impose penalty. Of course, for imposition of penalty by virtue of the amendment incorporating so and so, the joint cadre authority is to be constituted. Accordingly, my lord, thereafter, page 265, OA 64, this OA is allowed on this preliminary issue, charge memorandum, and all subsequent actions hereby quashed. This will not, however, be an impediment for the respondent to initiate fresh proceeding.
Where are you reading? Where are you?
264, my lord. 263, thereafter, conclusion part, 264.
Yes.
This OA is accordingly allowed on this preliminary issue itself. Charge memorandum dated so and so and all subsequent actions are hereby quashed. This will not, however, be an impediment for the respondents to initiate fresh proceedings against the applicant in accordance with law. So, my lord, against this judgment, my lord, Ministry of Home Affairs preferred writ petition. And writ petition orders are 265. My lord is feeling uncomfortable because of that.
No, it's fine.
265 are these are the orders passed by Delhi High Court. Delhi High Court has only issued notice. Stay was rejected by Delhi High Court.
This was regarding?
My lord, against the order passed by CAT,
okay,
MHA approached Delhi High Court.
Okay.
And Delhi High Court has been pleased to issue only notice that your lordship will find at page 268. Issue notice, learned counsel for the respondent accepts notice and seeks so and so, so and so. So only notice was issued. An interim was rejected by Delhi High Court that your lordship will find at page 291. 291, my lord.
291
is the stay order rejected by Delhi High Court, my lord. There is no interim order till date. There is no occasion to pass one at this stage. So Delhi High Court has not granted any stay of the order judgment passed by learned cat, meaning thereby the authority which has been given by learned cat is holding the field till today. Learned
So this was a separate or
this
in the same petition?
same petitioner, my lord.
Same petition filed.
I am respondent, my lord. Union of India versus Padma Jaiswal.
699.
Same, my lord. Same cause of departmental proceeding and criminal proceeding on the same allegation. So what I am submitting before your lordship, matter is still pending before learned Honorable Delhi High Court, and Delhi High Court since has passed only issued notice, no stay has been granted. So the judgment or passed by learned cat is holding the field. This is the law as prevailing as on today, your lordship. What is the law? That MHA has no jurisdiction to initiate departmental proceeding against the petitioner as it is in respect of the affairs of the particular state. Now your lordship may kindly see my additional affidavit. Additional affidavit, my lord. And page 476.
Additional affidavit.
My lord, it is in continuation of my petition. 476. This is the, my lord, allocation of business rules. This is the allocation of business rule, page 476, my lord, kindly see. And I am taking your lordship directly to page 508.
This is what 476 is.
My lord, it is the allocation of business rule of state of Arunachal Pradesh, where page 508, clause 9. My lord.
Okay, page?
Page 508. Heading 35, Department of Vigilance.
Yes.
Department of Vigilance.
Yes.
And para number 9.
Yes.
Interesting cases. Your lordship has got it, Mala? Interesting cases of allegation about corruption to CBI through the Department of Personnel, Government of India. So it is the duty, why I have shown before your lordship, it is the state government who will entrust cases to CBI. MHA cannot suo motu direct state government to give me copy of FIR and hand over it to CBI. And that is why section 17 capital A says of PC Act. Your lordship, it is amended. Amended. This is later. Section 17 capital A subsection B. Your lordship has got it. Section 17 capital A. It is in page number 28. Page number 28. At the top, your lordship will find page number. Font size is very small. That's why your lordship May I flag mark, your lordship?
No, no, just a minute. 7 and B is there, just a minute.
17A, capital A. '28.
Page 17.
Page 7, no, section 17, capital A.
Oh, no, page.
Page number in my this printout, it is 28, 28. I think it should be same. Or your lordship may take up this, I will find it out there.
17, oh, this is
17A.
Is this 16? 17A.
Capital A. I'm handing over to my
This
copy.
font is different, that is why. Yes, please.
Got it, your lordship. Inquiry or investigation of offences relatable to recommendations made or decision taken by public servant in discharge of official functions or duties. No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under this act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without the previous approval. Second, your lordship, B, clause B. In the case of a person who is or was employed at the time when the offence was alleged to have been committed in connection with the affairs of a state of that government. So it is the state of Arunachal Pradesh that can recommend for CBI inquiry. MHA cannot direct state government to send me a FIR, copy of FIR. When it was done, my lord, when they lost the battle in CAT, then they started calling the FIR, which was registered in 2011, in 2018, my lord, after quashing of departmental proceeding. Now I am taking your lordship regarding prosecution sanction.
Yes.
For that, my lord, I am taking your lordship to page 157, 191, 191. And your lordship may kindly come to this page 194. This is the order passed by, my lord, kindly see at the top, 194, Government of India. Prosecution, Government of India has given. And my lord may kindly.
Regarding prosecution sanction.
My lord, granted by Government of India, not by state government. As per section 19, it is the state. 199, my lord, kindly come. Everything has been done by government of my lord, my petition, my lord. Main petition, criminal. It starts from 190. It starts from 194 and relevant page is 199. It starts from 194, the relevant page is 199.
This is what?
This is the prosecution sanction order. It is in respect of, my lord, PC Act. In the charge sheet and cognizance taken again under IPC also, that I will come later, your lordship. And whereas
Relevant is
page 199. It starts from 94. I am taking your lordship to 199. Prosecution sanction order.
Yes.
199, para number 6. And whereas CBI has recommended for granting sanction for prosecution sanction under section 19 of PC Act against Srimati so-and-so, the Deputy Commissioner so-and-so, Arunachal Pradesh for offence under section so-and-so 420, so-and-so. Second, whereas Honorable Home Minister has approved for sending the proposal of sanction for prosecution against Sri Srimati so and so, the then Deputy Commissioner so and so. So why I am showing this, my lord? Thereafter, clause 8. Whereas Department of Personnel DOPT, Government of India has obtained comments and advice of the central CBC in the so and so, wherein the CBC has done so and so.
Now, which one reading?
Clause 8, para 8.
8.
8, thereafter 9, my lord. 9 is important, my lord. And whereas the competent authority, after duly and carefully examining the report of CBI, proposal of Home Ministry, Home Affairs, and its recommendation. So it is who recommended, my lord? Ministry of Home Affairs. That is I wanted to show before your lordship. Because it is up to the authority, they may recommend or they can refuse also. In the present case, recommendation has been done by Ministry of Home Affairs for the affairs of the state of Arunachal Pradesh. Home Affairs has trench upon a power which is specifically reserved for state of Arunachal Pradesh. That's why I would like to, thereafter, my lord, clause 10, sanction has been granted against me. Because today I am arguing only on law point, your lordship. In final hearing, I have given one compilation of judgments compilation, my lord. If it is not there, I have extra copy also. Now I would like to rely certain decisions, my lord. Before that, section 19 may kindly be seen, my lord. Section 19 of PC Act. Section 19. Before, my lord, I would like to clarify, prosecution sanction has been granted by Ministry of Home Affairs, recommendation of Home Affairs in respect of PC Act. But my lord, no prosecution sanction has been granted in respect of IPC. But learned trial court has taken cognizance in both the sections. For IPC, my lord, there is no prosecution sanction. But learned trial court has taken cognizance of the offense in entire section. Section 19, my lord.
Where the prosecution sanction has been granted against the IPC?
IPC has not been granted. This is the prosecution sanction only. The document which I have shown, page 190, 194, this is the order prosecution sanction. It is clearly written under section 19 only. It is specifically mentioned, my lord.
Under section 19.
Under section 19 only.
Where?
Page 200. Para number 10.
Yes.
Now, therefore, the competent authority hereby.
Where is the sanction for the IPC? What?
IPC, there is nothing.
No.
Sections are there. Sections are there.
Okay.
That I have shown, my lord. In charge sheet, it is there.
Charge sheet, you also will see at page.
Did you submit that the prosecution sanction was granted even in the IPC also?
No, it doesn't say.
Where is it?
I am just showing charge sheet, my lord, copy of charge sheet. Page 157. Page 159, your lordship may kindly come. 159. This is a copy of charge sheet. Page 159, your lordship will see. IPC sections 120B, 420, 409, 477A. PC Act 13(2), read with 13A.
Page number?
159, 159 of
the petition.
Petition, my lord.
Serial number?
Close serial number 4. Act IPC sections under section 120B, 420, 409, 477A. These are IPC section, my lord. Second PC Act section 113 to read with section 13(1)C and 13(1)D with substantive offences thereof. And the cognizance order, your lordship will see at page 201. And relevant page 202. Order taking cognizance. Next page is 202. Order is there.
This order of the
Order 202, my lord. It was downloaded from the website, my lord. 202. This case starts from this case.
yes.
This case is taken up on being mentioned by Miss So-and-so. London so-and-so has submitted that while order dated so-and-so after receipt of charge sheet, it was found that prosecution sanction was submitted only against one accused Padma Jaiswal, petitioner before your lordship. And prosecution against the two accused persons are still awaited, because of which the case was ordered to be listed on so-and-so for further order. But in the meantime, on so-and-so, the prosecution sanction against the remaining two accused persons, so-and-so and so-and-so, have been already submitted before this court. Therefore, learned so-and-so has prayed that since PS has been already submitted prosecution sanction against the remaining two accused, the case may be taken up into cognizance. After hearing the London Council and perusing the prosecution sanction, the case is taken into cognizance. Issue summons to all three accused persons for their appearance on the next. So, learned trial court has taken cognizance so far as entire sections are concerned on the charge sheet itself. The Home Ministry has granted prosecution sanction, which is, in my humble submission, is without jurisdiction, without authority of law, in respect of PC Act only.
Yes.
Now, my lord, some decision. Compilation has already been given, my lord. Those are flag marked.
Okay. So.
Madam, CBI has filed a detailed affidavit in opposition.
Affidavit?
Yes, madam, this morning only, madam. And as per the affidavit, madam, it is prima facie case that prima facie case has been made established against the accused persons, madam. And madam, regarding the prosecution sanction, madam,
she was working in Arunachal Pradesh only.
yes, madam. The controlling appointing authority.
Arunachal Pradesh, who is should.
Madam, all of IAS officers are being appointed by the President of India under the Ministry of Home Affairs, madam.
Maybe, but at the time of commission of alleged offense, he was working here in Arunachal Pradesh.
No, madam. Madam, the prosecution section has to be after all. Now, my lord, she has already been transferred back to the other states. And madam, of course, the prosecution sanction was granted by the Ministry of Home Affairs. Madam, the case was registered in Itanagar.
Yeah.
Madam, the prosecution section, after all, has to be given by the authority concerned who has appointed him, madam. She may be, madam. That is the number one, madam. And number two, regarding the jurisdiction, one thing, madam, the CBI has registered the case basing on the, madam, the directions from the, madam, the ministry. Madam, CBI is also established under the Delhi Police Act. Then the jurisdiction part is
maybe, but you see, the alleged offense was committed here while she was posted here in the state of Arunachal Pradesh.
Correct,
only, where she was working under the authority here.
Yes,
in Arunachal Pradesh. And the offense was committed here.
And she has been transferred.
Maybe supposing anywhere here in Itanagar also, supposing the person, automatically they will be transferred here. Only, of course, they are central service.
Madam.
But they are while they are being posted here, they are actually under the authority here in this state.
Madam, that's why, madam, my submission, respectful submission is, madam, though she has been posted in the state of Arunachal Pradesh, madam, the controlling authority, everything is the Union of India, madam. So therefore, madam, the major decision has to be taken by the ministry, madam. But madam, for time being, she has been transferred to the state of Arunachal Pradesh or any other state as maybe, madam. But however, madam, the only concern is, it is the Union of India.
Say, for example, a state government employee being posted, say Punjab, okay, for time being.
Yes, madam.
He has committed offense there.
Correct, madam.
Will the Police in
Yes.
Arunachal Pradesh will go and investigate.
State of Arunachal Pradesh will be the sanctioning authority, my lord, as per the provision.
He would be under some authority there,
My lord, authority.
under whom he will be working there.
My lord, he has been only, the IAS officers are being transferred to the state of the Arunachal Pradesh for time being, my
It's
lord.
not done in other case.
My lord.
It's not done in other case.
Other case,
The person working here and then straight away from Delhi, the case investigated from there, and then the action taken directly from there. It's not done in other
I'm
case.
not
In
aware,
any
my
other
lord,
case.
my lord, I'm not aware of all the cases. My lord, the cases relied upon by the petitioner is Huzar Lolen case, and Huzar Lolen case is not direct IAS officer, my lord. He has been, he was, my lord, the nominated IAS officer.
He's the IAS officer.
Therefore, my lord, the appointing authority is the governor of Arunachal Pradesh, my lord. So therefore, the prosecution sanction has been taken from the state of Arunachal Pradesh. That is one aspect, my lord. And regarding the registration of the case, my lord, ministry has done meticulous examinations on the issues, and thereafter finally granted, my lord, the prosecution sanctions to these officers, my lord. And my lord, had it been the case that she has been appointed by the state of Arunachal Pradesh, my lord, of course, my lord, the granting prosecution sanction is vested with the state government, my lord. But she is, my lord, the IAS cadre, IAS officer appointed by the President of India through Ministry of, my lord, the Home Affairs. So therefore, prosecution sanction has been, after meticulous examinations, my lord, granted by the ministry, my lord. Number one, my lord. Number two, my lord, another, my lord, registration of the case, my lord, regarding regarding jurisdiction of the case registered by the, my lord, the CBI, my lord, the jurisdiction, my lord, in Narendra Kumar case, my lord, if lordship remember the, my lord, the order passed by his lordship Justice Ansari, before he has been transferred to the Patna High Court. But in that case, my lord, just jurisdiction was raised. He was also the bank manager working in the the bank. Was basically from the Punjab and Haryana. And he has been transferred to the Nagaon, Sibsagar, nearby Sibsagar area. The Delhi police established under the Delhi Police Act. CBI established under the Delhi Police Act. Was one of the major issue that the CBI cannot register the case and examine the case, the persons who has been already transferred to the state of Assam. Thereafter, the case was at the very the establishment of the case regarding the power and functions to investigate the jurisdictions of the CBI was raised, and same is also one of the issues.
Let us see again the PC Act 17A.
Sorry, my lord.
17A. Just give him a copy.
I'm sorry, my lord.
Just read it.
Which one, my lord?
17A.
17A, my lord. Yes, ma'am. Inquiry or investigations of the offences relatable to relating to the recommendation made or decisions taken by the public servants in discharge of the official function or the duties. No police officer shall conduct any inquiry or investigations into the case, into any cases or any offense alleged to have been committed by a public servant under this act, where the alleged offense is relatable to any recommendations made or the decisions taken by such public servant in discharge of his official functions or duties without any previous approval. In the case of a person who is or was employed at the time when the offense was alleged to have been committed in connections with the affairs of the Union of India, affairs of the Union or the state government. B, in the case of a person who is or was employed at the time when the offense was alleged to have been committed in connections with the affairs of a state or of that state government, of that government, madam.
See? B,
madam.
B is the.
Madam.
Regarding, my lord, Arunachal, page 13 of compilation, my lord, Hojar Lolan case, he was IS officer, maybe nominated, but he was IS officer. Prosecution sanction was refused by my lord, state government. Despite that, my lord, trial court proceeded in the matter. He came to my lord, this honorable court. This honorable court has quashed the entire proceeding. That the page number 13, my lord, I have compilation that the judgment is there.
My lord, to that extent, my lord, the affidavit filed by this morning, my lord. Married para 12, page number, my lord, 587, my lord. Malam para 5 years, malam page number 587, malam para 12, malam.
Yes.
Details of the reply has been given, madam. The averment made madam. Averment made in para one of the petitions regarding the costings of the FIR number so and so dated so and so, along with the charge sheet dated so and so. The MHA prosecution sanctions dated so and so, and order dated so and so passed by the learned special judge CBI UPA are misleading and devoid of merit, hence denied. In reply, it is submitted that CBI ACB Guwahati registered an FIRs on the basis of the notifications dated so and so, madam. That notification is also given, madam. Of course, madam, and to that effect, it is not annexed. Issued by the government of Arunachal Pradesh under section, madam, 6 of the Delhi Special Police Establishment Act, which I am referring, madam, 1946, madam, followed by the notification dated so and so number, madam, issued by the Department of Personnel and Training, the Government of India under section 51 of the Delhi Special Police Act, Establishment 1946. And during the investigation, oral and documentary evidence collected, which established the complexity of the accused petitioner as well as co-accused persons. Accordingly, CBI filed charge sheet before the learned special judge CBI UPA under section so and so, and substantive offense thereof. This paragraph is important. It is further submitted that Ministry of Home Affairs, Government of India, being a competent authority, accorded prosecution sanctions dated so and so against the accused petitioners on being satisfied after examining the report of the material of the documents, including the statement of the witnesses recorded by the investigation officer and the after application of mine. Therefore, the order dated so and so, the learned special judge CBI UPA against the petitioner and other proceedings and orders passed in pursuance thereof are as per law, which requires no interference, manner, specifically. It is further submitted there in case of so and so state of so and so, it is reported in Manu, so and so online, Manu. It is, I'm reading the judgment portion. It is well established proposition of law that the criminal prosecutions, if otherwise justifiable and based upon the adequate evidence, does not become vitiated on account of malified or political vendetta of the first information or the complainant. So therefore, my lord, the prosecution sanction has been granted, my lord, after detailed examinations of the case, and had it been the case, then, if the ministry has no jurisdiction, definitely directly,
that's why CAT has quashed departmental proceeding.
Let us see your ruling which on the latest one.
Which one?
Citation.
Citations, madam. Compilation I have given your lordship. Flagged mark. First, your lordship will see page 13 regarding IS officer. Page 13, 1-3. Para 3, my lord, page 14. The brief facts page 13, page, start from 13, page, just mile.
This is okay.
Wow.
Okay,
Page 14, starts from 13,
yes.
para 3.
Hmm.
The brief facts leading to filing of present petition is that the petitioner is an IAS officer. This is very important. Of so and so batch, who was originally an APS officer, but of 1985 batch and posted in various capacities under the government of Arunachal Pradesh from time to time. During the period so and so, the petitioner was posted as deputy commissioner so and so, and thereafter he was posted as deputy commissioner so and so. Subsequently, petitioner retired from service as the commissioner public so and so. During the entire tenure of his service, the petitioner had discharged his duty as civil service officer very honestly and integrity without any blemish. Why I have shown so, my lord? In case of IS, in this case, what has happened, my lord? Para 18 to 25, he was an IS officer. Investigation was done. He may be promoted, but once he came in that cadre, he is an IS officer. So charge sheet was filed, and for prosecution sanction, state of Arunachal Pradesh refused to give prosecution sanction. Despite that, learned trial court proceeded in the matter. He challenged before this honorable court, and this honorable court says, no, without prosecution sanction, you can't proceed in the matter. Para 18 to 25, my lord. I am coming to my lord. Para 25 is the main conclusion. Page 22. Accordingly, page 22. Accordingly, the impugn of FIR dated so and so, registered under section so and so, IPC and Charge Prevention of Corruption Act and supplementary charge sheet number so and so in connection with the are hereby set aside and quashed for the impugned order dated so and so, passed by learned special judge so and so case, taking cognizance of offense and issuing summon to the petitioner as well as impugned order so and so, passed by learned special Lakhimpur, framing charges against the petitioner are hereby set aside and quashed. So prosecution sanction was refused by state of Arunachal Pradesh, because he was discharging duty in the state of Arunachal Pradesh. Since the learned trial court proceeded in the matter, so he came under 482. Now everything has been quashed by this honorable court. Regarding prosecution sanction, my lord, I am relying first judgment, page 1. It starts from 1. And my lord may kindly come to page 6. Page 6. My lord.
This was para 25.
Hujur Lunan, para 8 to 25. Para 18 to 25.
Okay, and then next is
start from 1. State of Karnataka Bhaskar C. Nagaraj Swami. Page 1. Page 1 and relevant page is at 6. Page 6. Paragraph 13.
Yes.
Para 13.13, my lord. May I read your lordship? The appellant proceeded against the respondents under the Act. Section 5 of the Act provides for the procedure and powers of a special judge. Section 19 of the Act mandates that no court shall take cognizance of offence punishable under the provision specified therein, except with the previous sanction or by the authority specified therein. This is very important. Authorities. Authority means the authority who has the jurisdiction. Next, my lord. Ordinarily, the question as to whether a proper sanction has been accorded for prosecution of the accused person or not is a matter which should be dealt with at the stage of taking cognizance. But in a case of this nature, where a question is raised as to whether the authority granting the sanction was competent, therefore, not at the stage of final arguments after trial, the same may have to be considered having regard to the terms and conditions of service of the accused for the purpose of determination as to who could remove from his service. Next one. Grant of proper sanction by a competent authority is a sine qua non for taking cognizance of the offense. It is desirable that the question as regards so and so, so and so. So, my question is this: whether the authority is competent or not, it has to be decided at early stage. It is not that why I should face trial by on the basis of sanction given by authority who is not competent. Next judgment, my lord, page 12. Very small judgment, my lord. Page 12. P.A. Mohandas versus State of Kerala.
Yes.
Para 2. The appellant is being prosecuted under the provisions of PCA. The High Court refused to entertain the plea of lack of sanction. Para 2.
Okay.
Page 12, para 2. The appellant is being prosecuted under the provisions of the Prevention of Corruption Act. The High Court refused to entertain the plea of lack of sanction for prosecution by the competent authority. This is very important, my lord. On the ground that it would tantamount to review of the earlier order of the and the court does not possess the power to review the earlier order. Under section so and so, no court can take cognizance of an offense punishable under section so and so, alleged to have been committed by a public servant, except with the previous sanction of the authority competent to remove the person concerned. In the case in hand, the Secretary Vigilance appears to have accorded sanction to prosecute. The appellant's case is that the so and so was authorized to grant sanction. Only on itna, there is no other order of the state government making so and so competent to accord sanction prior to the said date. This is that regarding authority, my lord. Regarding, my lord, at the time of granting prosecution sanction, what is required to be dealt, that was dealt by, my lord, Honorable Delhi High Court in the case of Ashok Agarwal versus State of CBI, page 47. And para 76, 77 and 78. Page 108. It starts from 47, page 108. It starts from 47, my lord, 47.
Yes.
And relevant page is page 108.
108.
Para 76, 77, 78.
Yes.
In view of the aforesaid stated facts, it becomes crystal clear that the entire record of investigation, including documents and statements of witnesses under section so and so, as well as the case diaries, were not placed before the sanctioning authority in order for it to apply its mind before grant of sanction order dated so and so. And said sanction order was passed only on the basis of SP's report dated so and so. In the first instance itself, the covering letter to the SP's report dated so and so is testament to the fact that the record of investigation in so and so was not sent to the sanctioning authority on the pretext that the investigation was very large in quantity. Further, the letter dated so and so of the Joint Secretary Revenue to the General Direct Income Tax and the letter dated so and so of the Director General Income Tax Vigilance sent to the Deputy Inspector General CBI expressly mentioned that the record of investigation was not sent to the sanctioning authority when the sanction of prosecution. Your Lordship may skip over para 77, my lord. The law in this behalf has already been considered at length herein above in adjudicating the same issue in writ petition number so and so would apply to the facts and circumstances of the present case so and so. Resultantly, that in view of the decisions of the Honorable Supreme Court in so and so, so and so, so and so, and in view of para so and so, the sanction order is rendered invalid.
This is criminal petition.
My lord, next, para 97, my lord, because if we are running from,
Have you filed a separate IA for?
no, my lord, here itself.
Here in this case only, it was.
My lord, I have given, I have prayed for
On the next day.
my lord. My lord, I have mentioned your lordship. Statement has been given in prayer portion. My lord, may kindly come to page 121, my lord, interim prayer. (121). Pending disposal of criminal petition, your lordship graciously be pleased to stay the further proceeding of so and so against the petitioner before the pending before the so and so with immediate effect till disposal of the present petition. So it is there, my lord. So in my humble submission, my lord, right now I am posted at my lord.
How many accused are there here in this case?
Total 3, I think.
Yes.
All of them are.
No, not
No.
before your lordship.
I
Only one matter.
no, total prosecution is going against 3, na? In the order itself.
No, my lord, before your lordship, only one petitioner is coming now.
The coming petitioner is only one.
No, what I'm asking, he is in the charge sheet already filed.
Yes.
Cognizance taken. So, how many accused persons charge sheeted?
Three.
All of them were government employed.
Or I am IS officer, or they are state government employee.
State government employee. So, state government employee, which department?
My lord.
Which department?
It is in the office of deputy commissioner itself, my lord.
Deputy commissioner. Okay.
So this is my respectful humble submission, my lord. You also make till disposal, my lord, because the trial court is proceeding in the matter, that may be stayed. And your lordship may expect this. They have filed affidavit. I will file rejoinder to that, my lord. Your lordship may fix a date. On that day, you also hear the entire matter.
So we'll do that. Let them file rejoinder.
As I already pointed out, madam, since
today itself they have
one
filed,
petitioner is before your lordship and the other petitioners are not before. So therefore, my lord, if lordship interferes in the proceedings of the learned court bill, my lord, that definitely affects the other accused person.
No.
Who is not at all seeking for stay.
The person who is seeking liberty.
And another my lord aspect is since this is.
Just a minute. What about the other, whether the prosecution sanction in respect of the other.
State government granted. State government. They are state government employed, so then it's all right. The person who is coming before your lordship will give relief to that only.
It is admitted that she was working here in Arunachal Pradesh at the time of commission of offense.
That part we are admitting.
Okay, so later.
And my lord, the next date is given, my lord, for the further proceedings of this case, my lord. If lordship interfere in the proceedings, my lord, after that bearing effects will be with 2 other accused persons who is not at all seeking, my lord, for the stay of the proceedings.
It will be in respect to petitioner only.
Well, that segregate cannot be done.
Where was the FIR?
FIR, madam. FIR. Page 123.
His lordship is already seen in my paragraph 12. Page number 587, madam. We have specifically mentioned, madam, the notification issued by the state government as well as the notification issued by the Department of Personnel and Training, madam. Wherein, madam, it has been clearly mentioned, madam, that of course, madam, documents is not annexed in my petition, madam, my affidavit. However, madam, it clearly mentions that, madam, this is in accordance with all the provisions as contemplated under.
We will file rejoinder, my lord. Then,
my lord, where the prosecution sanction.
Or your lordship may.
My lord, the provisions for granting prosecution sanctions by the Union of India, even if the officer is serving in the state of Arunachal Pradesh, that my lord, the notification is clearly stated.
This is not the correct lawyer.
And my lord, regarding my lord, I may be wrong, my lord, admittedly, my officer has not enclosed the copy of the. In fact, I sought for the my lord. Since it is, the abatement has been made specifically to that effect, madam, the notification in accordance with notifications, every proceedings has been done, madam. If lordship, madam, allowed me to, madam, access the documents, madam, will ask for the, madam, the producing of the documents, how this has been.
When next date is fixed, you said?
My lord, on
September-
that, on the last order, I will show. London trial court refused to grant me time, your lordship, despite the prayer was made, because this honorable court was directed me to apprise the court that the matter is pending. I have been directed to appear personally. This is the order, my lord. So without order, next date, this is the order part, last of it. We have given video clip also, everything, but London trial court refused to entertain us, our application.
Video clip of what?
For court recording, your lordship. Because this honorable court observed that orally you go before the trial court and make the mention that matter is fixed on matter is pending before this honorable court.
Next date is
Not
15, my lord, 15 September.
No, we don't want to spend one sleepless night because of this, my lord. Your lordship may fix it here finally. Until then, my lord, kindly protect me. Well, last from 4 times they are taking time. Today only morning they have filed affidavit, my lord. So this is my
It was hearing on charge.
charge, my lord.
Yes.
So on that, the charge was not framed.
They will hearing because I didn't appear now before London trial court.
Why you did not appear?
Because, my lord, it was challenged before this honorable court, and this honorable court was in the midst of hearing and directed us to file an application. That application was also I am placing before your lordship, disclosing
What
that
application?
disclosing that the matter is pending before this honorable
He
court.
appear once only, my lord.
My lord, when the prosecution is, my lord,
Because of that reason.
my
the
lord,
matter-
question is appearance when the prosecution sanction has been given by the authority who is not competent, not authorized, who has no jurisdiction. My lord, why I should face trial, my lord? Directly hit Article 21, my lord. Right now I am posted in Puducherry.
My lord, another proposition is, at the
My lord,
time,
unnecessary, my lord, delaying from the last five times, my lord, 4 times they have taken time, your lordship.
during the consideration of charges, my lord, that.
My lord, that cannot be. No one should be convicted before conviction. Appearing and facing trial is directly hit, my lord, Article 21. No one wants that someone should come in house. When someone will come one's house, then he can understand the pain of someone.
So therefore, my lord, at least let her, my lord,
That's
appear
right.
before the time when the consideration of charges
It is very
was
easy to
taken.
say. It is very difficult
Is
to say.
taken, madam.
From the last 5 times they have taken time.
Charge sheet was filed long years back, my lord, but my lord, the petitioner is
Why,
remaining
my
action.
lord, I will face, my lord? I have persuaded your lordship.
My lord, definitely
I have
that
persuaded
will
your
taken-
lordship that this is a fit case where, my lord, inherent power is required to be exercised in the interest of justice.
That will be taken into consideration, my lord.
My lord, your lordship may pass an order, my lord. I kindly protect me, my lord. I should not be compelled to join trial on the basis of prosecution sanction granted by authority who is not competent, not authorized, hence upon a power which is reserved for state of Arunachal Pradesh.
Ministry of Home Affairs is much competent enough to.
No,
manage
this
prosecution
is the
section.
problem. The order who is required to be passed, he can only pass.
What is the allegation? Is appropriation of what?
No, for 28 lakhs rupees.
No, my
This is 28 lakhs rupees. They are saying draft was made and that amount belongs to me by way of misappropriation of fund.
Offense
But I
is
have
serious.
given detail of that, my lord. Yet that your lordship will see. I have given explanation to that 28 lakh rupees. That will come, my lord, in the final hearing. I will satisfy, my lord. This is, my lord, kindly see.
My lord, the nature of offense is very serious, my lord.
Serious gravity of granting stay or bail is that should not depend upon the nature of the offense, gravity of offense.
So, when the charge sheet was filed?
Charge sheet was filed, my lord, page 157.
When?
I'm just. No.
30th August 2024, madam.
24.
30/8/2024, madam.
So after 10 years,
After
more than 10 years.
more than 10 years. Well, no, when they have filed.
See, appears only
My lord,
once.
because
of which, my lord,
because of quashing, my lord, of cat matter, because of the causing of departmental proceeding, my lord, with malified intention, my lord, Bhajan Lal says no prosecution should be launched on if it is based on malified intention. After quashing of departmental proceeding by learned cat and after rejecting the prayer, by Delhi High Court. They started this proceeding. Clearly smacks, my lord, something which what I can say, my lord. It is smacks.
See, whatever may be, but the misappropriation, whatever amount may be, but if the
My lord.
authority doesn't have a power, it's difficult. If the authority doesn't have a power to investigate and also to obtain prosecution sanction, then the court doesn't have again power to take cognizance.
True, my lord. Totally, my lord, totally agreed of the proposition done by the petitioner, my lord. But my lord, as I have pointed out, the prosecution has been granted and the sanction by the competent authority, my lord, basing on which the planet court below is competent enough to proceed further, my lord. And my lord, another point.
Now, what about this accused person, whether she is in service?
Service, yes. She is Secretary Puducherry, print and department. She is now Secretary rank officer, 2003 batch. She is in service. She is posted there in Puducherry. Only, my lord, after quashing of my lord departmental proceeding, they have taken over the charge of and hand over to CBI. Only the intention is not bona fide, it is malified, my lord.
And what about the two state?
My lord, state government, they may proceed if they agree. They may also come.
No, piecemeal proceeding cannot be, my lord.
Here's the
Because
question.
one of the accused persons.
I have to call them also. Please come. Always FIR and charge sheets are quashed in respect of petitioner, not in respect of.
My lord, just for a moment, my lord, may I take your lordships to affidavit filed by the CBI at page number, my lord? Just for a moment, my lord. Affidavit filed by the CBI, my lord, at page number, my lord, 592, my lord. Just for a moment, my lord. Affidavit filed by the CBI, my lord, this morning. And state government is also not yet filed my affidavit, my lord.
This is state.
Affidavit filed by the CBI at page number 592, my lord.
Additional affidavit.
No, my lord.
Okay.
Affidavit filed by the CBI, my lord.
CBI.
Yes, ma'am.
Yes. Page.
Page number, my lord, for a moment, may I take your lordships to page number 592, my lord.
Yes.
These are the, my lord, details of transaction, which is not at all, my lord, permissible, and it is restricted, my lord, it cannot be, my lord. But personal way of, my lord, the transaction has been made, my lord. Therefore, my lord, my lord, I'll skip, my lord, the tabulation part, my lord. Serial number 1, 2, 3, and up to 5, my lord. And the amount of debt has also been given, check number, draft number, so and so, and amount, my lord, from the government account. These amounts are transferred to, my lord, private individual who is as per the details of I am not making any submission out of this record, madam.
The case, there is a prima facie case.
Yes, ma'am.
It appears from the record, but see, the authority who should have been investigated and who should investigate has not done. So, but we are again governed by the law. Anyway, so what we'll do?
Another, my lord, the scheme of the prosecution sanction, my lord. My lord, my respectful submission is very scheme and very idea of the prosecution sanction is, my lord, is to be prosecuted to the officers who is serving in the state government or as well as the central government, my lord. Just prosecution sanction is much enough to prosecute the officers, government and servant. Therefore, this, if lordship perused again, the prosecution sanction granted by the ministry, it is very much clear. Even if it is not, the grant has been given for the prosecution of the government servant under IPC or any other provision. But in PCA, section 19 has been clearly mentioned, but it is well enough to separate prosecution is not required. It is well enough to prosecute the one officers. मतलब other PCA Act, मतलब IPC is the general provision, मतलब in the PCA Act is मतलब section 19 has been granted, मतलब other section 19, मतलब. So therefore, very scheme of the idea is it is not required to be मतलब the each and every
investigation also, investigation part.
मतलब the investigation part as I pointed out at paragraph 12, it is notified by the state of Arunachal Pradesh as well as the state of the notification issued by the Department of Personnel Affairs and as well as the expansions of the Delhi special.
That is general notification.
General notification,
Not
wherein CBI has competent to investigate the case of even if it is committed in the state of Arunachal Pradesh or
We
any
have
other
the copy of that notification.
That's why I made submission before your lordships.
Here the question
if
is
lordships allow me to produce some documents, I'll call from the record, Of course, it is mistakes on the part of the filing the officers in charge that without annexing such documents, important documents.
No, so
this has been filed.
immediately after this complaint, whether no forwarding, etc. Nothing. No, it was not forwarded. The CBI show moto came.
Show moto in directed state of Arunachal
Show the notification if there is any. If there is any that it was forwarded.
They have specifically mentioned, but that annexures has not been annexed, specifically, it has been mentioned at para 12, as Lordship has already seen. But the copy of that notification is not enclosed in the.
Yes, unless there is a copy, how do we?
Admittedly,
based on the submission.
To make pair submission, this has been filed in most haste manner, without annexing any single documents, which they are relying upon.
This was filed earlier.
No, this morning only we filed.
Okay. Now, if you have the copy notification to show to satisfy you, we can grant 1 or 2 days.
Just
before passing on.
Admittedly, if prosecution sanction has not been granted by the competent authority,
may I pray your lordship?
Why the officers?
Your lordship may take up this matter on 2nd of September. Till then, I may be protected. By that time, I also file my rejoinder, so that everything will be before your lordship. Because they have filed today itself, Malon. I will also go through it and I will file my rejoinder also. Till then,
no. What I according to me, so once the order is passed, it will be difficult again. So before passing order, I want to just ensure that if really there is a notification.
Otherwise, also nothing is going to affect. That's because matter has been already fixed on 15 September, madam.
So it's question of a few days.
Yes.
Okay.
Yes.
Before September.
Even if lordship interferes the proceedings, my lord, that will not be beneficial for the
because your lordship has heard at length, my lord. Again, my lord, your lordship may
that is your based on these are going to.
Or your lordship may make it part-heard. Because your other again I have to.
Part-heard would be difficult because nowadays after 1 month.
The state government is also not yet filed affidavit.
My lord, if your lordship will not be there again, my lord, we have to start everything, my lord.
No, everybody can understand. And if the notification is there.
Not a general notification, my lord. It is not as per section 17A. Section 6 of the Delhi Police Act. 17A, they have mentioned section 6. That is a general notification, my lord.
Respectfully, my lord, I have not also seen the copy, my lord. Therefore, my lord, that is very much important part of the record.
Since you are insisting, if you want to
this is under section 6, my lord. They are not saying 17A.
Statement, except the copy.
Yes.
Which you have not.
It is difficult for me to make submission also, my lord.
Yeah, that is why.
My lord, if matter is fixed on my lord, September 2nd September, my lord.
Till then, my lord, I
fixed on
2nd of September. Till then, my lord.
September.
Till my lord, because I have
nothing is
my lord from 5 occasion, my lord from 5 occasion.
We'll fix it on 13th August. 13 August.
13 August. Yes.
Because substantially I've heard. So that is why.
But my lord, my partner, if your lordship is making partner, then it would be my lord.
No, the 13th September I will be here.
13.
So 13 August.
13, I have some difficulty, my lord.
13 August I'll be here.
My lord, from 12 to 17 December, I have difficulty.
Giving an opportunity to learn it.
True, your lord, but I have difficulty, my lord, on 12 from 12.
In between, my lord, the hearing will be not proceeded, my lord. It's because matter has already been fixed on 15 September.
That is why. Before
your lordship may take up this matter on 7, my lord.
7 of
August.
Today is 4. 5, 6
Seven.
years, man.
By
Because
that,
they have
I'll produce documents.
Produce copy.
Seventh, I think we'll be busy. Seventh,
Or
we'll have hardly time.
11 I have met.
Seventh, we'll have hardly time.
Or day after tomorrow.
Then
subject.
day after tomorrow is
Or seven, if you can produce. Okay, seven.
Yes, 7 only.
It's prayed for by both the Rani Council for a party. List the matter again on 7.
7.
Okay.
Only my lord, my learned friend is going to produce
Yes,
that notification.
Because he has made some statement here.
Right, man. Deeply obliged.
Much about.
Your lordship may observe interim prayer shall be considered on 7.
Okay, on which date? Okay, then the presence of the Rani Council, Mr. Swenson, Rani Council for the petition. Heard Mr. Swenson, Rani Council for the petition. I've also heard Mr. D. Kato, DSTI, Rani Council appearing on behalf of the CBI, no?
CBI.
State is also the party.
CBI party. State is also party.
Okay. Okay, Sangita for the state is the
Formal party.
On the prayer of the Rani Council for the respondent. The parties, let this matter be set again on 17, on which date the interim prayer shall be considered.
Deeply.
Service complete.
Yes, please, my lord. My lord, I am for the appellate, my lord.
Yes.
We have taken steps, my lord, upon the respondent number 2.
This is for cancellation of bail, my lord, pertains to POXO case.
Okay.
And CD was called for, we have received the case diary, but your lordship, for cancellation of bail, your lordship, the trial court record would be required. What material
Yes,
has?
yes.
It was not called for.
That was not called for.
Only CD. The TCR would be required, and moreover, your lordship, service is not completed.
So the case has already been charged sheeted.
No, my lord.
Then?
It's not charged sheet, under investigation, my lord, but cancellation of bail, your lordship, they are filing, they have filed approaching this court for cancellation of bail,
Okay.
which has been granted by the special court.
It was granted by the special court. That record need to be.
Yes, absolutely. That has to be looked into whether the proper material has been appreciated by before granting the bail or not. And it's a POXO matter, so, and moreover, bail has already been granted, so your lordship, the accused must be given an opportunity.
Yes.
So notice has to be served. They have taken steps, but
Notice probably they have taken steps. You have taken steps.
Yes, sir.
service not completed.
No report on the service. Let's put on number 2. Okay. Mr.
M. Ratan.
Lana Council for the petitioner. Also heard Mr. D. at the Lana Public Prosecution. So additional public staff. It is submitted that the bail was granted by the special Judge POXO for Special Judge POXO Act. Therefore, the record would be necessary for consideration of the petition. So let the record be called for from the let the trial court record be called for. The although the office note reflect that the petitioner has taken steps upon the respondent number 2. Thereafter, they have not recorded.
Yes,
Your Lordship, the bail was granted in bail application number 287 of 2025, my Lord.
Okay, then let the record of
Yes, Your Lordship.
bail 287.
287, my Lord.
Record of let the trial court record in connection with the BN number 287/2025.
Yes, in ITA PS case.
In ITA
Women
WPS case number 43/2025, within bracket, Srimati Taikaku versus State of AP, bracket close, be called for. Okay. However, the last, the office note doesn't reflect regarding the receipt of the notice. In view of the above, the office, the registry shall reflect regarding the steps upon the respondent number 2 in the office note. Okay. In view of the above, let this matter be listed after 2 weeks.
2 weeks. Yes, Your Lordship. We have received the original case diary, Your Lordship. That may be returned.
Case diary, then
and
case
updated.
diary, the scan copy.
Your Lordship, yes, this is the original one, Your Lordship. We may be direct to return the original case diary and produce the updated scan case diary.
Okay. The original case diary has been produced. Stop. In view of the above, the original, since the case has been fixed after to be listed after 2 weeks, the original case diary will return.
Yes.
To be produced on the next date. To be produced on the next date. That's the updated CD. And scan copy of the
Yes,
updated
yes,
CD.
I'll-
Okay.
Oblige, Your Lordship.
They will list this matter after 2 weeks.
Yes, oblige, Your Lordship.
Yes.
Yes, my lord. My lord, this is application under section 528 of the BNSS.
This is transfer
Praying for
transfer from principal seat.
yes, and it was filed on the vacation bench.
Okay.
The step was taken, your lordship, but
this is question petition.
Yes.
Okay, Mr.
Proceed.
Counsel for the petitioner is present. You there is no record of you having taken steps upon the respondent.
Your Lordship, step was taken.
Record doesn't reflect.
Yes, it is not reflected in the record.
So you take fresh steps?
Yes, I may be allowed to take
Okay,
fresh step.
Who submits that? Who prays for allowing him to take fresh steps upon the respondent? The prayer allowed steps upon the respondent by a registered post with AD, as by usual process within a week from today. This is matter after 3 weeks.
Lordship, interim order may be
The
continued.
interim order passed earlier shall continue till the next date of this thing. Okay.
Obliged.
Is it contested case? Is a quashing petition or what?
Yes.
Is a contested case or
Yes.
contested?
On merits.
On merit.
On
Then
merit.
it can be referred to the mediation.
My lord, I had asked the party. He's not prepared, my lord, because this case arose out of a Lok Adalat order.
Okay.
So due to that non-compliance of that Lok Adalat order,
Okay.
a complaint case was filed before the learned.
He doesn't believe the petition.
So he is not willing to mediate.
Then what is the next stage? Steps? Scan copy of the TCR has been received. Now, have you filed objection?
If you will be arguing orally, my lord. We won't be filing any
Alright.
objection. Yes, sir. It's basically, my lord.
We'll list it in then before admission. Okay. Mr.
Itamin, lordship.
Line counsel for the petitioner.
Jitano, my lord.
Line counsel appearing on behalf of the respondent. Stuff. The trial court record. Scanned copy of the trial court record has also been received. Stuff. In view of the above, let this matter be listed after 3 weeks for admission. Okay.
Yeah, much obliged. Much obliged.
May I, Lordship?
Yes, you will forward it to.
Your Lordship, I'm appearing for the respondent insurer.
Okay. You are for respondent?
No, appellant.
Appellant.
Insurer.
We are respondent, Your
You
Honor.
will send it to the mediator?
Your Honor,
Mediation?
as per our counseling with their legal manager of the appellant, they are not going to settle the case. They are interested to.
No, you are for appellant?
Yes, Your Honor.
Appellants, okay, HDFC.
Lordship, the appellant does not wish to settle the matter since there is no scope of settlement. Lordship,
The challenge is regarding what?
regarding the impugn order passed by the
quantum or what?
passed by learned MSP.
Yes. What order was passed?
It passed, Your Lordship, award of rupees 11,48,000. Since
Why you have challenged? You have challenged on quantum or what? What is your challenge? Why you have challenged the impugn order?
since the award is exorbitant and excessively high, Your Lordship.
Oh, that is why that can be settled in the during by way of mediation.
Lordship,
You can bargain.
as per the company, they clearly instruct me to
not to go for mediation.
Yes, Your Lordship.
Okay,
But
then
my
what is the
lord,
next issue?
but my lord, in court number 1 today, one case is listed as analog case.
Yes.
That case is also fixed for mediation. So
Same.
this matter may be fixed for mediation.
Try once.
Yeah.
In any case, this will be not listed for 2 weeks. So try once. If it doesn't settle, it will come back automatically. Automatically, it will come
Yes,
back here because
yes.
this is only with regards to the amount, the quantum of the compensation. So there is a element of settlement.
Yes.
Okay. Mr. You are Mr. Hakim Tamin.
N. Ruza.
Hmm?
N. Ruza.
Learned counsel for
N.
the
Ruza.
appellant. Also had Mr. Das, learned counsel appearing on behalf of the respondent staff. On perusal of the record, there is, sorry, not Procedural. There is a element of settlement of the matter before the before the mediator. Let this matter be forwarded to the mediation, forwarded to the mediation, forwarded for settlement through mediation. The registry is directed to forward the matter before the special mediation for the within inverted comma special mediation drive mediation for the nation for settlement through mediation.
Yes.
Okay.
My lord, item number 33, 34, same analogous case.
Okay.
Lordship, my only prayers is that according to my client company, they wish to contest the matter on merit, Your Lordship.
Okay.
They don't want
mediation.
It will automatically come back.
Yeah.
Okay.
Okay.
Okay, Lordship.
Okay. Try once. Because there is a mediation drive is going on now. So in that, just try once.
Yeah.
If it is unsuccessful, you indicate there in the mediation center, we are not going to settle the matter through mediation. So they will automatically send it back.
Yeah.
Okay. Yes.
My lord, in this case, step was taken. Step was taken, and it is by usual process and AD.
So this is also, so the opposite party.
There is
not
only one
appearing.
sole respondent.
Sole respondent not appearing.
I am appellant, my lord.
You are appellant.
Yes, my lord.
Respondent is not appearing.
Not appearing, my lord. Notice was not served. My lord.
Not yet served.
Not yet served.
Then no point sending it to be for mediation. It's not possible unless the party appear.
Yes, my lord. Yes, my lord.
Okay. Mr. Das, Lana Council for the appellant is present.
Take a fresh steps.
No one appeared on behalf of the respondent. So Mr. Das, pray for allowing him to take fresh steps upon the respondent. The prayer is allowed. Steps upon the respondent by a registered post with AD as well as by usual process within a week from today. Let this matter be listed after 4 weeks.
My lord, in this matter, they have prayed for quashing of the case, my lord. So, because the trial is going on before the learned JMFC.
It's a contested case.
Yes, therefore it cannot be go for mediation. It's already a trial is going on.
Trial is going on.
Yes, negotiable
What
instrument.
is the offense involved? Is it offense?
This is negotiable instrument, man, check bounce case.
It can be sent, can be forwarded if it is.
Because the main, they have actually challenged the interim order.
They are challenging the
Yes, interim order.
Interim order.
Yes.
That is why I'm saying.
Yes.
If this matter is settled through mediation.
Yes.
Then they will come with an agreement that the case also will be withdrawn.
But when they have not been able to settle the interim order,
No,
I don't think the main suit, they will agree to settle the main.
Or what
it's
you
difficult, man. He's not appearing also before the court below now. In the last non-bailable warrant has been issued. Last proceeding.
Before the trial court.
Yes.
Or what do you say? What is your instruction?
Behalf of Tita Bhak.
Okay.
And instruct me send to the medicine center.
So he wanted to participate.
Yes.
But he is not appearing in the court before the court.
He's not appearing. For several occasions, he's not appearing. He's basically challenging the interim order in this criminal petition.
What is the interim order?
Interim order directing him to pay the allotted list.
Is there any stay?
15% of no.
Stay on the interim? No.
Yeah, no stay. Lordship is 15%.
15% of the check
Yeah.
amount.
Yes, page 45.
The interim come.
15% of this order was passed in November 2024. He has not even complied with this order till it.
So what to do?
My lord, this matter can be argued on merit, my lord. Ultimately, we have to see whether the interim order passed by the trial court was right or wrong. My lord. That has to be decided in, my lord, criminal petition.
You are Mr.
B. Sibu.
Land Council, had Mr. B. Shivo, Land Council for the petition stuff. Also had Mr. P. Tapo, Land Council appearing on behalf of the respondent. Mr. Tapo submits that the trial is the trial before the trial of the case is no, he is not appearing since then.
No.
Okay.
For several occasions thereafter, he is not appearing. The Lordship can see the order is of November 2024. Now it's August 2025.
Mr. Tapo submits that the petitioner, who is the petitioner, he is a respondent.
Yes.
Accused or
Accused.
accused. The petitioner who is the accused in the before the trial court is not appearing before, not appearing. Who is accused is not appearing before the trial court. And he has not yet paid the interim direction. He has not yet complied with the interim direction to pay 15% of the check amount.
Yes.
As interim compensation to the complainant in complaint case number 44/2023. Although there is no stay. No stay.
No, stay, madam. Actually, there's no merit in the petition itself, madam. So this honorable court has seen in this petition, madam.
Of the said order, huh? So, under the circumstances, it will be difficult. Under the circumstances, it will be it's not a difficult, under the circumstances, it's not a difficult to, it is otherwise not a difficult to send it before the mediator.
The problem is that the amount is of 50 lakhs. The interim order passed was for 15% of that amount also. When he's not able, because he was present when the order was passed. After knowing 15% also is not paying, then the question of paying the main amount, I don't think he will.
Under the circumstances, forwarding the matter before the mediation would not serve any useful purpose.
Yes,
useful purpose. Huh?
Yes.
And therefore, we praise. Therefore, we praise that the matter may be proceeded before this matter be proceeded before this court. Huh? Okay. In view of the above, since he is appearing, okay, let this matter be listed after 2 weeks.
Yes.
Okay, 3 weeks. Huh? 3 weeks.
Problem.
Okay.